Yes. No,
I mentioned
one
one
explain. Yes.
Only?
Yes, Mr. Sara.
Your Lordship knows my lord, only one matter so far the vacancy is concerned relating to the entry point age of the fair price shop dealer, my lord. Your Lordship passed an interim order in 2-3 matters. The state preferred an appeal. If your Lordship kindly see, an order has been passed at page 6, paragraph 16 onwards. If your Lordship kindly read page 6, paragraph 16 onwards.
Yes.
So without touching any of the observation, only modified the interim order with direction to file affidavit within 7 days and 3 days. And affidavit has already been exchanged with the request to your Lordship to hear out the matter as early as possible. None of the observation has been interfered with. Only on the issue that the virus is challenged at the interim stage, it normally interim order may not be passed.
The same shall abide by the result of the proceeding.
My lord. So if your Lordship kindly
If license issued.
yes. And with a direction that there should be a rider that license is being given in terms subject to the result.
Subject to the result of this.
What I am paying before people have to kindly fix the date at any day. Because almost your Lordship hear out the matter, all judgments have been placed, and that has been observed by the division bench also.
This is
Last paragraph.
Which matter, Mr. Sara?
This is age 45, entry point. Hair pipe shop dealer, the cartel.
Okay, I understand.
At the entry point, but
there are several matters.
So 4-5 matters. I shall give all the numbers.
The batch of
yes. I have put 5-6 matters. Another 2 matters are also there. I shall give the number because that's the observation of the division bench. All these matters be considered.
So there are no affidavit by the state in these matters.
Already, state has filed affidavit. We have filed also reply because
in
division bench directed to file affidavit within 7 days. Mandatory.
Okay. They have
filed. We have also filed reply.
Okay. So matters, all the matters are ready.
All the matters are ready.
So what do you want?
Any day, my lord, subject lordship at 10:30 any day because your lordship already heard the matter. And your lordship kindly see in paragraph 20 it has been observed that none of the observation of your lordship is interfering with by the division bench. And without influenced by this order, your lordship will consider the same. Any day at 10:30, any day. So that the matter can be finally heard a single hearing.
Learned Advocate General would be appearing in this matter, I think. So, 23rd of July, 2 p.m. one matter is fixed for learned AG is arguing on this matter.
In my matter?
23rd, yes, your matter. So this matter can be fixed on that day?
It cannot be fixed at 10:30 at any day. Any day.
10:30, I think not.
Some matters are being fixed by your lordship. So, otherwise, if license is granted, this process under process, that's true.
Within 15 days, they will issue another more license. I can understand.
Because
23rd, 10:30.
I'm much of get your
23rd, 10:30.
Number
Give me the numbers.
Yes, sir.
Numbers.
Other numbers I am.
Other
numbers I am.
All the matters so that the matter appear all together.
There are 6 matters. 4 moved by me, and my learned friend also moved 2 matters.
Very well. 3 batch of matter I shall pass the order.
I have 5 matters.
Okay.
I will
Give the number.
I get much of. I am giving you.
All will appear 10:30, 23rd.
Lordship,
Yes.
Permitted to mention this matter. If the Lordship recalls, second appeal, there was an application for occupational charges. The Lordship had fixed this matter yesterday at 2 p.m. But as your Lordship was not sitting, the Lordship can fix this matter any other day. We have served notice. The opposite side counsel is also there.
Okay. 17.
We are appealing for the response. So Chaturvedi was addressing your lordship.
Just for our reply now.
Right. It will appear automatically on 14th.
14. Lordship,
As
before
well.
that,
Before I would be at Jalpet. First day it would appear on 14th.
14th at 2 p.m.
No, not 2 p.m. It will appear before that. 2 p.m. is it? 2 p.m. fixed. Then it will have 2 p.m.
2 p.m.
Very well it will appear.
Much of it. Much of it.
My lord, may I be permitted to mention one extension of interim order, my lord, which will be expired, my lord, on Monday. Now, my lord, from Monday your lordship is not available.
Yes.
So until and unless, my lord, determination given to the justice, my lord,
Determination would be
my lord,
otherwise.
Monday will expire my interim order.
To mention Monday before the appropriate bench having determination.
But the same date on my lord, my
Today it can be written.
if it can be, my lord, fixed on, my lord, 2 p.m. I will serve notice to the others.
No, no, not possible. Not possible. 2 p.m. some other matters are there. এগুলো গতকালের matter ছিল, সব Monday তে আসবে তো 14th এ আসবে all matter. Okay. Yes, you can give the mentioning slip so that the matter can be appear before the appropriate on Monday.
Very
Okay. Give me the mentioning slip. Name যে বেঞ্চে আসবে যে বেঞ্চে আসবে তুলে দেবেন under the heading to be mentioned. ঠিক আছে? Monday. Yes.
ফাইলটা আমরা আনিয়ে দিচ্ছি।
The state has sufficient.
Yes.
Yes. But we wish to file a written notice of argument for which period I need period of his time. If your lordship permits me to come back after the, and I will take minor valuable time of check. Because the state has responded to argument since the UGC has taken a stand which is conducive to our interest. So Miller, we will not interpret we will exhibit our points and we will rely on
Today the matter is fixed for 12:30 for your argument on reply.
Yes, but I need
So what you want?
I want a week's time, I pray.
Okay. 1 week's time for okay.
I can pray Miller.
So not 1 week, 2 weeks should be there. 2 weeks should be there. I would not be there. You understand?
Any date period at 12:30. I'm extremely grateful.
Item number 4. Please take down item number 4. On the prayer of the learned counsel appearing on behalf of the petitioner, let the matter be adjourned today. List the matter on 15th at 12:30. 15.
My lord, may I have your lordship's my lord, may I have your lordship's kind leave to mention, my lord, your lordship earlier occasion, my lord, granted leave to move the matter, my lord, yesterday, my lord. The matters appeared yesterday, my lord, item number 11 and 12, my lord. My lord, if your lordship can issue a supplementary list today, my lord, then, my lord, these matters can be taken up by your lordship, my lord, since there is
Today I have other determination. You know, group 1 matters are pending.
If your lordship, a supplementary list, my lord, these two matters, my lord, since, my lord, your lordship granted leave, my lord, and, my lord,
Leave for what?
my lord, leave to file and move the matter, my lord. The matter appeared yesterday, my lord, but, my lord,
Then you have to move
and, my
to
lord,
the bench.
your lordships
Monday.
will not be available, my lord.
I understand. But the situation today, some group 1 matters are piling there.
Anytime today, my lord, at even at 3:30, my lord, if a supplementary list
No,
is
I can understand. But today, since 2 p.m., I have the original
ordinance.
side determination.
I know, my lord. I appreciate, my lord. Your lordship is burdened, but, my lord, only 2 matters, my lord. Otherwise, my lord, termination order can be given effect, my lord. And, my lord,
Who is for the state?
Well, I shall inform the state, my lord. One in Shapun Dattu, Mr. Shapun Dattu is appearing in another matter.
Usually, I do not take up the matters, group 8
I
matters
know, my
today.
lord, I know.
That's
my-
why they would
I
not
know, my
appear.
lord, but since, my lord, your lordship will not be
They
available
would
from.
not appear. Ask them. Ask
But
Mr.
I shall
Dotto.
inform them. I shall
Ask
inform.
Mr. Dotto whether he will available at
My lord,
4:15. I can arrange.
4:15. My lord, kindly issue a supplementary list, my lord, so that my lord.
You ask Mr. Dotto if
But
he
I shall
consented-
inform him. I shall inform.
No, you ask him. Otherwise, it would be not possible for me.
But today at 4:15.
Not 4.
But
I am
your
not
lordship-
fixing. If
My lord,
I
if
can,
lordship keep the matter, my lord, I shall inform and bring him, my lord. Otherwise, when if it is not kept, my lord, he will not come.
আছে লিস্টে নেই মেনশন করেছিল মুভ করবে না যদি আসেন তাহলে হবে করাই হ্যাঁ মুশকিল হবে লিস্টে আসেন তো আজকে তাহলে কি করবেন লিস্টে এলো না কেন ওটা মেনশন করেছিল ওকে টুডে ইজ গ্রুপ 1 matters difficulty is there you mention Monday before the
Monday, my lord,
appropriate-
your lordship will not be available, my
I
lord.
understand, so what can I do?
My lord, this is the problem, my lord, my lord.
Group 1 matters are there, I have to deal with
My lord,
them.
today at 4:15, my lord, I shall inform the London advocate for the state,
I
my lord.
want the consent of Mr. Dotto, otherwise
I shall, my lord. In the course of the day, my lord.
you inform him.
But
otherwise-
will he keep the matters, my lord? I am informing him.
Not
Otherwise,
keeping
my
the
lord,
matter,
not
this
come.
is not in the least, you understand. I have to pass
Well,
an order to
kindly-
frame a list.
Kindly issue a supplementary list, my lord. Then, my lord, pursuant to
No.
that.
If they are available, then I can hear.
Okay, my lord, then, my lord, I am coming.
They would not hear available today because this is not group 1.
No, they are available, my lord. They are in the court,
Okay,
my lord.
inform them.
My lord, my lord.
Lordship,
I
may I
have
be
to pass any order.
may I be
okay?
permitted to mention one
If
matter?
they are
of
ready,
this
then I can.
matter was heard by your lordship in earlier occasion. There is a twofold prayers. One is relating to the group 8 and another is relating to group 9. That police has given some report. I am agreed by the report, lordship. I move this writ application. Your lordship was pleased to release the matter for the lack of determination, and subsequently it is reassigned before your lordship. So lordship, kindly be let the matter
Reassigned?
listed, assigned before your lordship. Now this matter has come as assigned matter, lordship.
Okay.
I have informed from the office of the chief justice, lordship.
After 14th. Yes.
After lordship, that
may I have your lordship's
because
kind-
there are certain urgency because I am a contested candidate as per the controller of 2013
Not
vacancy.
before 14th.
Yes. After 14.
Yes.
lordship.
it
May
will
I have your
appear.
lordship's kind leave?
Group 1 matter for what? For inclusion in the list.
My lord, may I
You serve.
My lord, may I have your lordship's kind leave? My lord, this matter was released from the list of her leadership justice Amrita Sinha on account of lack of determination. It's a group 1 matter, my lord. I'm mentioning only for inclusion. I've served much of it.
Permitted to mention one matter by extension of interim order, my lord, similar to my learned senior friend who my interim order expiring on 30th of June, my lord. Kindly be placed on Monday before the bench having
Group 1 matter.
No, my lord, this is the food corporation related to food corporation of India, madam. Not
Food Corporation of India.
But I'm not sure about the group, my lord. The interim order expiring on 30th of June, my lord.
Whether this is whether I have the
Yes, yes, my lord.
determination. Essential Commodities Act.
Yes.
Monday.
Good.
Lord, may I be permitted to mention? My lord, it is for upgradation. Yesterday, it has appeared in the daily list of 53. Can it be heard today?
No. Today I don't have determination of group 8.
But your
I have
lordship,
group 1 determination.
the private respondents are making several nuisance. Can it be heard, please?
Group 8 matter.
Yes,
Why? What nuisance?
the private respondents are creating several nuisance. The petitioner preferred representation, file this suit here, and the private respondents are saying that they will not give the license of that.
Private respondent, no, not private respondent. The respondent authority, whether given license or not.
No, not given license, but we have all the documents.
You are the petitioner.
Yes, my lord.
Okay. So come after 14th.
They have managed kindly to mention in respect of WP number 27453 of 2024. This matter was heard by your lordship on 16th of June. June. And your lordship was pleased to make the matter CAB and directed us to file the notes of argument. But notes of argument could not be prepared by.
That's why I understand.
That's why your lordship kindly grant me leave till Monday. By Monday I will file my notes of argument to hand over to your lordship's court officer. to my
You file it after 14.
as well.
It would be better, otherwise not possible.
Due to my personal difficulty, I think.
Okay, okay.
My lord, mentioning for restoration application, my lord. The matter has been dismissed for default in January 2023, and the application is being filed along with application under Section 5 of Limitation Act.
When you file the application for restoration?
It will, my lord.
When you file the application for restoration? What are the grounds for restoration?
My lord, it is been dismissed for default, my lord.
For what is the ground for restoration?
But I don't know, my lord.
Then you make known yourself. Get ready. This is not the matter. By way you are coming and listing the matter. Call the list. কই তোমার সিনিয়র ব্যস্ত আছে আজকে না ওকে Akbar Ali versus State of West Bengal. I am reading only the operative portions. I make it clear this court is not an appellate authority to the decision of selecting authority. This court is only considering whether any arbitrariness or malafide, nepotism or favoritism has been committed by the selecting authority in selecting private respondent. In this case, after perusing the entire documents, reports, I find no malafide on the part of the selecting authority. Merely proposed shopcom go down of the private respondent is away about 900 meters from the central location cannot itself be a ground to disentitle private respondent to get the license when there is a specific report of concerned BL and LRO that there is approach road in front of the proposed shopcom go down of the private respondent. Under the above observation, the instant writ petition appears to be not meritorious, and the same is hereby dismissed and disposed of.
Grateful, Your Lordship.
Next.
I'm for the State Lordship.
Continue করো, proceed করো।
Where is Mr. Sengupta? He is not appearing today. Where here? Please, yes.
No.
Got the written instruction. This is a copy. Where is the original?
She sent me in mail.
Mail. Okay. Learned counsel, Mr. Ramesh Dhada, learned counsel appearing on behalf of the petitioner submits that the petitioner doesn't want to proceed with this matter further. Mr. Dhada further submits that he received the mail communication from the petitioner and he placed the copy of mail of the written instruction of the petitioner. Let the written instruction of the petitioner be kept in record. Full stop. Considering the submission of the learned counsel, also considering the written instruction of the petitioner, the instant writ petition is disposed of as not placed. Interim order passed by this court during the, if any, during the pendency of the instant writ petition is also vacated.
Lordship, in that instance, Lordship may only add one line that there is no bar to issue any license now since they have withdrawn. And in merits also there was no,
Only vacated all interim orders.
there was no interim order. There was no interim order, Lordship. If Lordship kindly, there was.
Wait. The state authority may proceed with the selection process according to the law.
Grateful.
I appeal for the petitioner, my lord. Led by Mr. Shoma Mojumdar. The petitioners have not substituted lessee in respect of a plot of land in Durgapur under the ADD, Asansol Durgapur Development Authority. They are the development authority in the area. My lord, governor has given the lease. We are the substituted lessee. Original lessee with permission has, my lord, transferred the residual leasehold right to us with consent of the, my lord, government. So we are the substituted lessee. Our lease deed, my lord, is at page 19. The crux of the matter is this. I'll place the lease deed. The crux of the matter is, my lord, we have challenged, my lord.
Page 90.
Page 90 is the lease deed. I'll place the.
What is the writ petition about?
Writ petition is about challenging an order by which they have permitted us to convert it for group housing, but they have imposed some charges apart from transfer fee, my lord, conversion charges, which is not there in the statute, which is not there in the lease deed, and which is not beyond jurisdiction. So they have charged something which they cannot charge. Apart from the transfer fee, we have already paid the transfer fee and the other charges. But this charge we are challenging because it is without jurisdiction, dehoes the statute. That is under challenge. That order is, my lord.
Where is the order?
My lord. Page 59, 30th May 2017.
Asansol Durgapur Development Authority.
My lord. Lord, may I place this order or should I place the lease deed and we'll come back to this order, my lord? I just wanted to show, my lord, what is the relation between the.
Show me the lease deed.
My lord, kindly comes to page 19, my lord. If your lordship.
19.
19. Kindly comes to page 20, my lord. The state is giving the lease, the lessee, lessor. Lessee are, my lord, Ratan Agarwal and Ashok Dalmia, the petitioners before your lordship. Page 20.
Who are the lessee?
We are, my lord, Ratan Agarwal, Ashok Kumar Dalmia. We are the transferee lessee, second party. And, my lord,
item page number 20.
Page number 20 of the writ petition, my lord.
Page number 20. Ratan Agarwal and Ashok Kumar Dalmia.
They are, my lord, before your lordship. They are this transferee lessee. And, my lord, the third party are not the persons who were the original lessees. Nonigopal Pan and others.
So, this property was leased out by the government of West Bengal in favor of Ratan and Ashok.
Yes, my lord. Ratan
and who
Ashok.
are the other persons?
Other persons, they were the original lessees.
Original lessee.
Original lessee. Nonigopal Pan and others. 34 lessees. The leasehold right was transferred to me. Residual leasehold right was assigned to us. We are the transferee lessee. Kindly
That means Ratan Agarwal and Ashok Kumar Dalmia.
They are the transferee lessee. Hereinafter called the transferee lessee.
Transferee lessee.
And third part are the original lessee.
Third part are the original
lessee.
34 in number.
Transferal lessee. Yes, 34 in number. They are called transferal lessee. This was the arrangement. They were the initial lessees. Then the leasehold right was transferred to Ratan and.
Very good.
Now, my lord, kindly comes to. I'll just show the relevant clauses. Page 24. What was the purpose of the lease, my lord? It has to be residential. Kindly takes note of clause 5 and clause 7. To use clause 5 and clause 7. Two clauses, I'll just show. Show the nature of the lease, to use the demise layout plot purely for purpose of erecting building for residential purpose and use it after construction for the same purpose. In default, they have a right of resumption. And 7 is also to construct after getting the permission from the appropriate municipal authority. So this is the purpose of the lease.
Yes.
Now kindly comes to next page, clause 12. Clause 12 is not important because what they can charge for transfer, not to transfer or dispose of the leasehold interest of the lessee in the layout plot, save and except upon obtaining prior permission of the lessor in writing and subject to payment of requisite transfer fee as may be fixed by the authority and or as may be amended from time to time by the lessor along with difference of land premium and other charges, if any, and after ground floor roof construction is completed. So, whatever is prescribed by them, if any other charge and the transfer fee can be levied by them. This is the periphery. Now, these are not contractual relationship. This is not guiding what shall be the charges to be levied. Only those charges which are not implemented.
Yes.
Now, I'll be relying, coming back to this clause because this is not the periphery of the relationship and not the power that they can exercise for transfer. Then we made the application for transfer to group housing, which was permitted. So, prior permission. First is I have to take prior permission. Second is I have to pay the charges, transfer fee, land premium, and the other charges. Now, kindly come to page 59. On the basis of my application, formula transfer of leasehold interest to group housing, this is the letter allowing us the transfer. This is under challenge along with the subsequent notice, my lord.
Page 59.
Page 59. With reference to the subject noted above, this is to inform you that the authority has considered and allowed you to transfer your leasehold interest of layout JP so and so measuring 18.13 kata in favor of Ganapati Cooperative Housing Society for group housing purpose, subject to compliance of the following formalities within a fortnight from the date of receipt of this letter. Permission is granted. A, the proposed transferor has to pay the transfer fee of rupees 40,79,250. Transfer fee as per the lease deed. Ground rent from 2012-13 to 17-18, rupees 1140. Interest of defaulted ground rent. Then conversion charge of rupees 81,58,500. And development charges for institutional use. So they are incorporating a conversion charge of 81 lakhs, which is under challenge. According to us, it is neither implemented in ADDA nor the lease deed permits it. So this is a charge without jurisdiction. This is a charge without jurisdiction. Development charge and the other charges. We pay the transfer fee, but we were not aware of the fact that this conversion charge was it was imposed upon us without jurisdiction because we did not have the information, requisite information from at that point of time. We made some correspondence. This cannot be, this is very high. They might say it's an act of acquiescence, which is not, because subsequently we went on making queries through RTI. What are the scheme? What are the charges you have implemented? From those RTI reply, we came to learn that this was never implemented in ADDA. I'll come back to those RTI, my lord. The next page is a letter by which initially we said that the rate is high, it should not be so much. Page 60. Conversion charge is very high because we were not aware that this is illegal. Then we made RTI. Kindly come to page 63. At present, the questions were, queries were, my lord. The present conversion charge per kata from ADDA residential leasehold land to group housing cooperative society in Sagarbanga Zonal Center. This is first query. Second query is the current transfer fee per kata from ADDA residential leasehold land to group housing. And 3 is, please also inform me whether the aforesaid 1 and 2, conversion charge and transfer fee, are both applicable or not for a single ADDA leasehold land. These are the specific queries. Now that kindly comes to the next page. These are the reply, my lord. I'm placing the replies. First is, my lord, with reference to the queries raised by you, reply to query number 1. Queries raised by you under RTI Act 2005 and specifically pertaining to your application under the above referred act, this is to inform you as regards query number 1. No conversion charge in connection with the issue raised by you has been implemented by ADDA. Number 1, kindly mark this, my lord.
No conversion charge. That is reply number 1.
Reply number 1. So they are saying, my lord, that no conversion charge has been implemented by ADDA. First admission. Next, my lord, the authority has implemented demand for transfer fee, which is half of the difference of land premium.
Authority has implemented.
And query number 3, with reference to the queries raised by you under RTI so and so, specifically pertaining to your application under query number 3, the following charge in connection with the issue raised by you has been implemented by ADDA. Now, kindly marks this also: transfer fee, processing fees, name registration fee, development charges. So they have specified what are the charges they can levy. First is they have not implemented conversion charge. And secondly, they have specified what are the charges they can levy. Now, kindly read this, page 64 with page 25, clause 7, once, page 25, clause 12. If 64 is read with page 25, clause 12, not to transfer or dispose of the leasehold interest of the lessee in the layout plot, except upon obtaining prior permission of the lessor in writing and subject to payment of requisite transfer fee as may be fixed by the authority and or as may be amended from time to time by the lessor, along with difference of land premium and other charges, if any. So the other, what are the other charges? That is now specified in page 64. Now, my lord, then, my lord, we made further queries because we have to also satisfy ourselves. This lease was for residential purpose, and we are asking for residential group housing. So we made a further query, page 70. Page 69 is the query, my lord. 70 is the answer. I'm reading page 69. Kindly come.
Yes.
69. The query was, what is the basic difference of criteria if a land allotted as residential plot and subsequently approved as residential group housing in leasehold land of ADDS command area? Whether such allotted residential plot and approved residential group housing in leasehold land of ADDS command area are both meant for dwelling purpose or not?
What is the first question, number 1?
Question number 1 is, what is the basic difference of criteria if a land allotted as residential plot and subsequently approved as residential group housing in leasehold land of ADDS command area?
Okay.
Whether there is a difference or not, because we're asking for residential group housing, we shall create a group housing where our relatives and our known person, they will get total 24 flats. It's a group housing. So whether that is a residential purpose or not. Now kindly see the answer, my lord. Reply of query number, page 70, next page. Query number 1.
Yes.
The terms and condition of lease deed differs in case of residential and residential group housing. Residential land is allotted to individual for single dwelling unit for residential purpose only. Group housing plot is allotted to residential housing cooperative society consisting of multiple dwelling units for the members of the cooperative society. Then 2. Residential plot and residential group housing plots both mean for residential purpose only. So both are, my lord, for residential purpose. Now, my lord, if your lordship now comes back to the impugned memo at page 59. Page 59. Now, my lord, kindly see, my lord, what are the charges, my lord, they have leveled. First is, my lord, they have allowed the permission. Prior permission is a requisite. Prior permission has been given. They have given the permission subject to these charges. Now, my lord, number 1 is transfer fee. This is not admitted. We are not disputing that. Ground rent, interest on defaulted ground rent, conversion charge, development charge. So the conversion charge is not fitting in the scheme of the act or the lease deed anywhere, my lord.
Yes.
So, my lord, admittedly, my lord, there is no provision for them to implement this conversion charge. They have used an affidavit in opposition in which, my lord, they have gone, my lord, to a large extent, my lord, challenging my locus, my delay, but they have not, my lord, on merit, they have not substantiated under which provision they have charged the conversion, my lord, conversion charges. Now, subsequently, my lord, we made representations pointing out, my lord, these letters. My representation is at page 71. Through my learned counsel, I make representation, my lord, pointing out all these memo given to us, all the letters which show that it cannot be charged, setting out all the RTI replies and asking for, my lord, remission of that part of the, my lord, letter. To which, my lord, they have they have not replied, but this is this sum and substance of the challenge. Now, my lord, they have received the transfer. Previously, when previous change was made, annexure P1, kindly see this was for the same plot. When the first transfer was allowed, what they have charged? Page 17. This is when the original lessee transferred their interest to the substituted lessee. 18th May 2011, after which my lease deed was executed. Kindly see what they have charged. With reference to the subject noted above, this is to inform you that the authority has considered and allowed you to transfer your leasehold plot consisting of CS plot number so and so, measuring 18.13 kata, with building in favor of Sri Ratan Agarwal and Sri Ashok Kumar Dalmia, subject to compliance of the following formalities. The proposed transferor shall have to pay the difference of land premium from the rate of allotment of rupees 35 per kata to the current rate of land premium of rupees 1,50,000 per kata. So you will have to pay rupees 1,50,000 minus 35 into 18, so 27,18,666 only in lump sum. The proposed transferor shall have to pay the transfer fee to the authority of rupees 21,000. The proposed transferor shall have to pay ground rent of rupees 380. The proposed transferee, Sri Ratan Agarwal and Ashok Dalmia, shall have to register their names in the authority or payment of rupees so and so. So all these things were paid, my lord, at the first instance when, my lord, the first transfer was made, permitted. After this, the lease deed was executed. So the payment is page 18. Payment in terms of, so they have never said, my lord, conversion. Page 18 is the, my lord, payments made, then lease deed is executed. Now, my lord, if your lordship, we also made further queries. We inquired whether, as per development charge, they can charge, whether there is any provision as per their notification for charging anything for this conversion. But we obtained the notification dated 18th of October 2011 at page 65, which is the notification for development charge, page 65. Kindly comes to page 65 once, my lord. This is their own notification. Now, this is, my lord, subject is 18th October in exercise of the power conferred under section 102 of the West Bengal Town and Country Planning Act and rules framed thereunder, as amended from time to time with the previous sanction of the state government in Urban Development Department. It is hereby notified that the development charge, as approved by the Board of ADDA in its 114th meeting, shall be levied on the carrying out of any development on change of use of land in the whole of the planning area of Asansol Durgapur Development Authority. This is partial modification of the Board of ADDA's 105th meeting and notification. So, in case of conversion or in any cases, they can charge the development charge. Now, my lord, kindly comes to page 67, my lord. B, rates proposed for change of use. Here, my lord, this is the only thing that I could find. Residential to commercial, previous, the rate is, my lord, differential land premium. Now, this is not residential to commercial. So they have not implemented for group housing.
Okay.
Only residential to commercial. Had it been a commercial, then the differential of land premium can be charged. But so far as not housing to group housing, nothing is implemented in their own notification. Now, in my humble submission, my lord, a statutory authority can do only such things as are permitted by the statute. They cannot do anything. These are difference between a natural person and a statutory authority. Natural person can do anything except which is not, he is restricted by statute to do. If there is a restriction, I cannot do that. And a statutory body only can do the things which are permitted by the statute. But, can my senior take over? My senior has come.
Yes.
There can be no second thought that every piece of earth on this planet belongs to the state unless owned by a private. Every particle of earth or soil. All land belongs to the state unless expressly owned by a private body. Now, this land was owned by the state and it still is owned by the state. Now, the state had given or executed a lease deed in my favor. Please come to that lease deed at page 25.
Yes.
I need not trouble your lordship with the entire lease deed. Please come to page 25.
25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25 Yes.
Kindly comes to clause 12. Internal page 7 of that lease deed, which is running page 25, clause 12. These are the restrictions imposed on the lessee by the lessor. Not to transfer or dispose of the leasehold interest of the lessee in the layout plan in part or in full, save and except upon obtaining prior permission of the lessor in writing, and subject to payment of requisite transfer fee as may be fixed by the authority or as may be amended from time to time by the lessor, along with difference of land premium and other charges if any, and after ground floor roof construction is completed as per the approved plan of the local body with sewerage and water connection, and so and so. So what is permitted? Obtention of a sanctioned plan for the purpose of construction, and number 2, on payment of the requisite quote-unquote transfer fee.
Yes.
Now, this transfer fee as ascertained was paid way back in 2011, which your lordships has been pleased to find at page 18. Rupees 27 lakhs 40,496. Read a check number so and so for 17 lakhs 40,000 and 10 lakhs on SBI. Difference of land premium transfer fees, as your lordship got that second item on that. Ground floor, ground rent for so and so, and requisition for in form of R. Agarwal and A.K. Dalmia against SP land at so and so. R. Agarwal is my client. Is the petitioner before your lordship?
Yes.
Now, what does this impugned notice purport to demand? Please have a look at page 59. With reference to the subject noted above, has your lordship got that? With reference to the subject noted above, this is to inform you that the authority has considered and allowed you to transfer your leasehold interest of layout so and so measuring 18.13 katas in favor of Ganapati Cooperative Housing Society Limited for group housing purpose, subject to compliance of the following formalities within a fortnight from the date of receipt of this order. Please come to clause A. The proposed transferor has to pay to the transferee pay the transfer fee of 40,79,250 only. Ground rent from 2012 to 2013 to 2017 to 2018 of rupees 1,140 and interest of defaulted ground rent of rupees 285. Then conversion charges of rupees 81,58,500 and development charges for institution of use of 18,197 in one lump. Transfer fee, I understand. That is within the parameters of that lease deed. Acting on behalf of the state, this local authority or not this planning authority is charging from me. But what is this conversion charges levied for?
So this is for residential purpose to the resident same.
And not there. Oh, please come to page 64 of the writ petition.
Reply to the queries.
Yes, not this is probably one of the most important legislations which have not thrown so much of light to litigants. Please come to query at page 63 first.
Yes.
Query number 4 at page 63. Please also provide me the board meeting resolution copy in which the above mentioned issues passed. What were the issues mentioned? The current, please come to paragraph 2. 1. The present conversion charge per kata from an ADA residential leasehold land to Group Housing Cooperative Society Limited for residential purpose in your Sagorbhanga Zonal Center at JP Avenue 2 command area. The current transfer fee per kata from ADDA residential leasehold land to a group housing cooperative society limited in your Sagorbhanga Zonal Center and JP Avenue 2 command area. Please also inform me whether the aforesaid 1 and 2 conversion charge and transfer fee are both applicable or not for a single ADDA leasehold land. These are the queries, but please come to the reply at page 64. Reply to query number 1. With reference to the queries raised by you under the RTI Act and specifically pertaining to your application under the above referred Act, this is to inform you as regards query number 1. No conversion charge in connection with the issue raised by you has been implemented by ADDA. The authority has implemented demand for transfer fees, which is half of the difference of land premium. With reference to the queries raised by you under the RTI Act, as regards query number 3, the following charge in connection with the issue raised by you has been implemented by ADDA: transfer fee, processing fee, registration fees, development charges. So there is no mention of conversion charges. Please see another document, right there, the own stand, page 70. This is also issued by the authority. The terms and conditions of lease deed differs in case of residential and residential group housing land. Residential land is allotted to individual for a single dwelling unit for residential purpose only. The group housing plot is allotted to residential housing cooperative societies consisting of multiple dwelling units for the members of the cooperative society. Residential plot and residential group housing plots are both meant for residential purpose only.
Yes.
But may I take my lord's kind leave?
Now, my lord, for the same authority to say that I am saddling conversion charges for the purpose of changing one residential unit to multiple residential units is not only dehones their own sanction or authority, but also repugnant to the clause of the lease deed, being the owner of the land, executed by the owner of the land.
Yes.
Now, what does this issue pose before your lordship's court? Now, it poses a question which may assume a larger importance. But please visualize the situation. The owner of the land, being the state, says that what is reposable or chargeable is only transfer fee. And the parastatal of the state says, no, you have to pay conversion charges for the same purpose against which it was leased out to you. So the parastatal of state, being a creature of a state, under a statute or by a statute, not overturns or not surpasses or not subsumes the conditions of a lease between the lessor and
is there any notification to that effect?
no, but I have shown to your lordship pages 64 and 17, the RTI replies. It's probably one of the most important legislations that the post-independence country has seen. But apart from this transparency meted out through the RTI Act 2005, my client could not have come up before your lordship's court. I would have bona fidely assumed that he was whatever he was saying is correct. So the parastatal of state is acting contrary to the conditions of lease, not where the state is the executor or lessor.
So your prayer is only conversion charges may be resigned.
But they have demanded so many fees. Please come to page 59. But they have said transfer fee, ground rent, development charge, processing fee, time extension fee, conversion charges. But I'm agreeable to everything else but the conversion charges, because I'm not converting the land for any purpose other than residential.
Okay, what is their affidavit?
Not their affidavit, please come to page 7. Now they have taken, I'm sorry, they have taken a point of alternative, on the alternative remedy, a different remedy.
You are for the state? Yes.
Remember, the important issues raised in the writ petition are not answered at all. Please come to paragraph 7 at page 3. Paragraph 6 rather. At page 3, that on 30th May 2017, the present respondent, after consideration of the prayer for development, directed the petitioners to pay certain amount on account of transfer fee, ground rent, interest on defaulted ground rent, conversion charges, development charges, processing fee, regularization charges, time extension fees, and so on, etc.
Mr. Mojumdar, you are reading from paragraph
6 at page 3.
Page 3 of their affidavit on behalf of the.
So it's a report in the form of affidavit in the backsheet of Mr. Sharanyo Chatterjee. Affirmed on some day of 2022.
24th August.
24th August.
By ADDA?
ADDA, yes. Respondent number 2.
Respondent number 2. Yes.
Please come to page 3, paragraph 6.
Page 3. Page 3, there are B, C, D like paragraphs.
Huh?
Is this a...
It has a franked number 43/22 at the top.
Opposition. That's opposition.
This is opposition. This is an opposition. There is a report, not if your lordship.
There are reports. Yes, it's got that. Okay, report. Page
3.
Yes.
Paragraph 6.
Paragraph 6.
That on 30th May 2017, the present respondent, after consideration of the prayer for development, directed the petitioners to pay certain amount on account of transfer fee, ground rent, interest on defaulted ground rent, conversion charges, development charges, processing fee, regularization charges, time extension fees, and so on, etc. Such an order, please take note of this. Such an order was passed in exercise of powers granted under section 46 of the Act. Your lordship kindly takes note of the word order as used in that affidavit. That section 47, I'm sorry, that the said order dated 30th May 2017 has been annexed to the writ application as annexure P5. Now that's page 59. That section 47 of the Act provides for appeal against order under section 46 of the Act, and such appeal has to be preferred within 1 month. That instead preferring such an appeal, the petitioners prayed for reconsideration of the quantum of conversion fee by letter dated 5th June 2017. The petitioners merely challenged the calculation of conversion fees but never raised any question regarding ADDA's authority to levy such a fee. That such prayer was also disposed of by letter of 22nd December 2017. That thereafter the petitioners failed to take any steps, and after 5 years this writ application has been filed. Accordingly, the present respondent has raised the question of maintainability of this writ application in view of availability of alternative remedy, enormous delay in filing the writ application, to bypass the laws of limitation. That the petitioner has tried to make out a case that his prayer before the authority was not for development but merely seeking transfer of their leasehold right. Such argument has no legs to stand, as the petitioners have clearly sought permission for development of land and has submitted a detailed project report in respect of the real estate project sought to be undertaken under the veil of an innocuous transfer. Such detailed project report has not been disclosed by the petitioners before this honorable court. That, as the point of maintainability urged by the present respondent in this report is being kept restricted to such points of maintainability and is not dealing on the merit of the case, the respondent reserves its right to file opposition then it says it's a stale claim, and these are the basic points also taken in the opposition. If your lordship kindly takes page 6 of the opposition, that's also the same stand taken, that they have only provided the basis of calculation in page 6 of the opposition.
Yes.
That same grounds reiterated in the opposition as well. The only difference is they have provided a basis of calculation which is in addendum to the report. Please come to page 9, paragraph 7. And I skip over that calculation part. Please come to page 9, paragraph 7.
Yes.
With reference to paragraph 7 and 8 of the writ application, the answering respondent emphatically denies and disputes all statements made therein, save those which are matters of record, and states that it has been admitted by the petitioner that as per the lease deed, the purpose of such lease was residential, and as per the lease deed and the West Bengal Town and Country Planning Act, it is pertinent to mention herein that as per the lease deed, the petitioner was under an obligation to erect and complete construction of the building within 3 years from the date of the lease, but the petitioners have unscrupulously kept the same vacant. It has to be kept in mind that the answering respondent is custodian of public land, and there is huge demand for such land. The petitioners have misused the lease as an avenue for investment of surplus money in real estate with a clear motive of undertaking real estate venture when prices are soaring for maximum returns. Accordingly, in spite of their incapability to finish the construction within 3 years of the lease, the petitioners after a decade now wants to enter into a real estate venture at the cost of public money and resources. Now, where does this question of public money and resources arise? Not in the teeth of the admission that is only the custodian of land?
Yes.
And you are charging this. You are charging transfer fee, ground rent, development charge, processing fee. What you are authorized to charge. I have no objection with regard to paying these fees as are chargeable by the authority itself, but not conversion charges. Because I am not converting a residential plot of land into a commercial or a semi-commercial plot. And that's page 70 of the writ application. Their own stand.
There you go. Okay, I understand. Okay, that's all.
Yes. Now, they say not only to satisfy your lordship's kind conscience, they say it's a question of limitation, and I wanted clarification of the conversion charges. Not first of all, I did not know. I took their stand on face value. It was my fault that I treated a statutory authority to be acting bona fide and truly. Now, when the RTI reply came, that I have approached this court. I thought that this was a decision. Now they say they have not implemented such a decision.
Yes.
So that there can be no waiver of right against a statute. Number one. Number two, there can be no question of limitation in this case. Now, please come to the prayers in the writ application. Now, there are two orders impugned. One is of 2017. Please come to page 14. Two orders are impugned. One is of 2017. The other is of 21.
Prayer B is the memo dated 30th of May
2017 and
dated 8/11/2020.
21. And I approached the writ court in 2022 after getting the RTI replies. 2021 is page 62.
Page 62.
Yes. This is to inform you that your prayer for extension of road width in front of the allotted plot measuring 18.13 katas up to 40 feet from its existing width of 20 feet has been considered and rejected by the Board of ADDA. In view of the above, you are also requested to comply with this office letter dated 30th of May 2017 within 90 days, failing which your prayer for transferring the leasehold interest of the said land with a layout plot number so and so in favor of Ganapati so and so for group housing purpose will be treated as cancelled without making any further reference to you. Will be cancelled. Will be treated as cancelled. Please see the language employed in that paragraph. Your prayer in favor of Ganapati cooperative for group housing purpose will be treated as cancelled. So unless you implement that decision, it will be cancelled. So it's really not a concluded question.
Yes.
Now please come to two particular provisions in the Town and Country Planning Act, which the respondents want to lay their hands on for the purpose of saying that it does not apply. There is a provision for appeal. Please come to section 2, subsection 7. But please see, first note what is the purpose of the act, the object of the act. Please come to the object part of it.
Yes.
An act to provide for the planned development of rural and urban areas in West Bengal and for matters connected therewith or incidental thereto. So it's really a planning authority. Now please come to section 2, subsection 7. Development. Development with its grammatical variations means the carrying out of building, engineering, mining or other operations in, on, over or under land, or the making of any material change in any building or land, or in the use of any building or land, and includes division of any land. Similarly, if there is a vacant land and if one person wants to construct us a 2-room house, that is also development.
Yes.
Any material change in any building or land or in the use of any building or land.
Yes.
So that's why not page 6, page 70 said the land is not, the purpose of the land is not being changed. The user of the land is not being changed. It was for residential purpose. It is for residential purpose. It's not the change of use. That's page 70 of the writ petition.
Yes.
Now please see page 46. I'm sorry, section 46. Section 46.
Yes, section 46.
Permission for development. Now they say it is an order under 46. Any person or body, excluding a department of the central or the state government or any local authority, intending to carrying out any development or township project on any land, shall make an application in writing to the planning authority or development authority for permission in such form and containing such particulars and accompanied by such documents and plans as may be prescribed. On such application having been duly made and on payment of the development charge as may be assessed under chapter 9, the planning authority or the development authority may pass an order granting permission unconditionally or granting permission subject to such conditions as it may think fit, or refusing permission without prejudice to the generality or clause of this subsection, the concerned authority may impose conditions to the effect that the permission granted is only for a limited period, and that after the expiry of that period, the land shall be restored to its previous condition, or the use of the land permitted shall be discontinued. For regulating the development or use of other land, any other land, under the control of the applicant, or for the carrying out of works on such land as may appear to the authority expedient for the purposes of the permitted development, the concerned authority in dealing with the applications for permission shall have regard to the provisions of the land use and development control plan, the regulations, if any, made under section 139 and applicable to the land on which the development is intended to be carried out, the building rules, if any, of a panchayat or a municipality, insofar as they are not inconsistent with the regulations as aforesaid and are applicable to such land, the provisions of land use and development control plan as forwarded to the state government under section 31 and any other material consideration. The provisions of subsection 1 shall not apply to the applications under subsection 5. When permission is granted subject to conditions or is refused, the grounds of imposing such conditions or such refusal shall be recorded in the order, and the order shall be communicated to the applicant. Where is this order? And I have shown to your lordship page 59.
59.
That's only a notice of demand for charges.
Yes.
Now it also that section 46 in section 46 subsection 2 refers to chapter 9. Now please see the heading of chapter 9. What is chapter 9? Levy, assessment and recovery of development charges. But it starts from section 102, ends with 106A. Please see chapter 9. In accordance with the provisions of this Act and the rules made thereunder, and with the previous sanction of the state government, every planning authority or development authority shall by notification levy a charge. But the state government in its executed lease says that you can only charge transfer fees. I am liable to pay transfer fees. So the question of employing section 102 for the purpose of this conversion charges is contrary to statute. State government has not said that I have granted you permission to charge these conversion charges or levy these charges. The RTI reply says that there was no such decision taken for implementation.
Okay.
PC 103, rates of development charges. But why section 46 and chapter 9 came into force? This was to control the hands of the authority. These are the controlling or enabling provisions to control their powers. Please come to 103, rates of development charges. The state government shall by notification fix up the rates of development charge for the following. For the institution of use for residence, for industry, for commerce, for change of use from agriculture to residence, from agriculture to industry, from agriculture to commerce, from residence to industry, from residence to commerce, from industry to residence, from industry to commerce, and for carrying out any other development under this Act. So, within section 103, state has been empowered, number one. Number two, the law itself makes a distinction between the purpose or use, which is commerce is different from residence, industry is different from residence.
So the state government has the authority to issue a notification if such conversion is chargeable or not.
Number one, and for what purpose? Change of use from residence to industry, residence to commerce.
These are the
These are the categories. How can the planning authority go beyond section 103 now? It's residence to residence.
Okay.
What is an order?
Yes. Section 46, subsection 4 says an order has to be passed.
Order has to be passed.
Yes.
What is an order? Your Lordship probably knows this by heart, but still I am borrowing the definition of order from CPC, section 2, subsection 14. Order means the formal expression of any decision of a civil court, which is not a decree. Of course, this is not a civil court, but there has to be formal expression of a decision. What is a decision? Section 46 has laid down the guiding principles. You bear in mind these factors before you pass an order for refusing permission.
Yes.
And if this is beyond statutory provisions, who can lay down? The state government by notification. What is section 103? Section 103 says from residence to agriculture, agriculture to residence, residence to industry, residence to commerce, then it is change of use. And now, just to show how the state government has acted, please come to page 65. Please come to 65.
Yes.
In exercise of the powers conferred under section 102 of the West Bengal Town and Country Planning Act and rules framed thereunder, as amended from time to time, and with the previous sanction of the state government in the urban development department, with a notification dated 19/9/2008, it is hereby notified that the development charge as approved by the Board of Adda in its 114th meeting shall be levied on the carrying out of any development or change of use of land in the whole of the planning area of ADDA. Please come to page 67. The first chart, rates proposed for changes of use. Residential to commercial, residential to others, industrial to commercial, others to residential. So there is a differential land premium. What is leviable is a differential land premium, not conversion charges.
Yes.
Which is 40 lakhs as already decided by them, or charged by them rather, in that notice of appearing at page 59.
Okay.
I understand generation of public revenue, but not in a manner which is not prescribed by statute or at the cost of citizen. But there is say an 8 kata plot of land on which a very rich person constructs a house. So it's a residential purpose. 8 persons who do not have that much of a money to construct that big a building, decides to construct 4 floors and reside on that. That becomes a commercial building. These are my submissions.
Yes.
Okay, I have lordship.
I'm led by Mr. Basu.
Yes.
Kindly grants us any one other day. But he was here, now he has been engaged here before the Honorable Division Bench.
So,
Then 17.
ADDA is the answering respondent.
Yes. Yes.
State is not the answering respondent. Okay. Today, if not, then it would be appear after 14. That is the difficulty. Otherwise, this day is the day.
But can it be on the 15th then?
Just right. Let me see. Yes. Huh? You should be দেখুন তো বৃহস্পতিবার 16, 17. No, 17.
Thursday is 17.
17th.
17 is a Thursday, right?
17th. Hmm? আচ্ছা 18. আর 10টা আছে। 12:30 রাখুন। 12:30 রাখুন। দেখুন 17-তে 24-এ কি আছে? 12:30. Okay, 24th at 12:30.
24th.
Yes. Prior to that, I don't have it. Argument on behalf of the petitioner concludes. Let the matter fixed for argument on behalf of the respondent authority within bracket ADDA on July 24, 2025, specially fixed at 12:30.
Make it part and make it
Okay. তাহলে প্রথম হলো matter made part.
obliged.
Next.
Time for the petition. This matter had appeared before your lordship on 13th of June 2025, when upon the prayer made by my learned friend, no time to file affidavit in opposition was extended.
Who are you? You are?
I'm for the petitioner.
You are for the petition.
I'm for the petition. Dada.
Application for amendment of writ petition.
Yes, my lord.
That is can 2.
Can 2, my lord.
So,
my lord, the interim order is also expiring today. Lord, I don't know whether my learned friend will be using affidavit or not.
Affidavit?
Of the application, those are recommended consent candidate for because of the application, they want to file amended, they didn't file. I wanted the matter to be heard because they're enjoying the for very long.
No, what is the application?
No,
Can
my lord, my lord, may I place, my lord, very shortly, the reason as to why this amendment has been initiated. My lord, originally the writ petition was filed, my lord, challenging an order dated 23rd March 2022, passed by the respondent number 2,
Estate
manager, my lord.
Estate manager.
Yes, my lord. Under the provisions of State Manager Miscellaneous Provisions Act.
Yes.
Challenging an order dated 23rd March 2022, passed by the State Manager Miscellaneous Provision Act, holding myself as an unauthorized occupant. But apart from the documents and merits which is all there in the writ petition, in the form of rent receipts, in the form of letters issued by the state manager accepting myself as a tenant, my lord, a plea was taken before this honorable court that Section 5 of the State Manager Act authorizes state government to appoint any person as the state government deems fit and proper for adjudicating the issue whether the person is unauthorized occupant or not. The plea taken before this honorable court that since it's a quasi-judicial person, there has to be some prescribed qualification, there has to be some recruitment process following which state government ought to have followed for recruitment of the state manager.
May I contest very shortly?
No, my lord, I would request my.
I'm arguing in your favor.
Okay, sir.
Try to understand the path. Yes.
Too junior to understand, sir.
Subsequent knowledge. And in this case, that we want to challenge the notification. Possibly the question of law, possibly the lordship will not stand in the amendment. Maybe
they want to challenge the
well, already the section. Yes.
notification. Subsequently, they came to learn that it was not within their knowledge.
So application being can 3 or
can 2, my lord.
Can 2.
My lord, it was filed on 3rd of April 24.
Okay. Can 2. I take can 2. Can 3. Application for seeking leave to amend the writ petition.
My lord.
What amendment you want?
Well, that is at page number.
What amendment, proposed amendment?
That's very page number, my lord. Amendment, schedule of amendment is there, page 8, my lord.
Schedule of amendment.
My lord.
Paragraph 25, A, B, C, D.
Oh, yes, my lord. 25, B, C, D, and E.
E. Okay. Please take down. Can 2 of 2024. This is an application seeking leave to amend the writ petition filed by the petitioner. It is the contention of the learned counsel for the petitioner that the petitioner came to know about the impugned notification dated 24th May of 1988 after filing of the instant writ petition.
Paragraph 4, my lord, I have stated, my lord. Internal page 4, paragraph 4.
Writ petition. It submits that without the said notification be challenged in the writ petition, all purpose and purport of the writ petition would be frustrated. For that reason, the petitioner intend to amend the pleadings as well as the prayer of the writ petition. Learned counsel appearing on behalf of the state raised strong objection and submits that the entire character of the writ petition would be changed and it is not permissible under provisions of Order 6 Rule 17 CPC. It further submits that the petitioner may file a separate writ petition for the cause as raised in the writ petition, for the cause and grounds, for the cause and grounds as raised in the writ petition. Full stop. Having heard the learned counsel for the parties and considering the application being Can 2 of 2024, it appears to me that the proposed amendment as reflected in the pleadings as paragraph 25 B, capital B to 25F, as well as ground V capital G to V capital J, and the prayer being within bracket A, small a. Hmm. Shall not change the nature and character of the instant writ petition. Moreover, the issue involved in the writ petition can only be determined if the pleadings and prayers thereof be amended in the instant writ petition. Accordingly, the application being Can 2 of 2024 be considered and allowed. The petitioner is the application for amendment is allowed. Full stop. Petitioner is directed to amend the writ petition and prayers thereof by placing a amended writ petition within 2 weeks. 2 weeks. Within 2 weeks after serving a copy of the same to the learned counsel for the read. Full stop. Let the matter go out of the list. Parties are liberty to mention.
My lord, the interim order be extended.
Okay. On such the state respondent is at leave to use affidavit in opposition against the amended provisions of the writ petition.
My lord, may I pray for extension of interim order?
Because the point they are enjoying the interim order for a very long time. Point is the filings of the act. We have issued order of eviction. He says we don't have the authority. That is a limited question.
Not before August.
Whenever you
My lord, liberty be granted to use affidavit in reply. I'm praying, my lord, for extension of interim order.
Okay. The state respondent is need to file the affidavit within 3 weeks after receiving of the copy of amended writ petition. Full stop. The petitioner is also at leave to use reply against the affidavit within 2 weeks thereafter. কি করলাম তাহলে 2 weeks and 1 week. তাহলে 5 weeks. Okay, very well. Let the matter appear in the list on August 21st, 2025.
August 25.
Interim order, next part. Interim order passed by this court on the earlier occasion is further extended till August 29, 2025, or until further whichever is
Grateful, my lord. Extremely grateful.
to disposed of. Hearing. Under the heading hearing. Under the heading hearing. Can to disposed of. Next.
Item number 6, Millard, kindly give me leave to appear virtually. Millard, item number 6, Millard, is my writ petition. Millard, appearing, Millard, after Millard, the substitution is being done. Now, my lord, Millard, the pleadings are complete. Millard, kindly allow me to file the reply. Millard, my advocate on record, Millard, is in court. It's appearing after a long time.
Reply is ready.
Reply, Millard, served on the other side. Millard, it has to be filed before your lordship.
Very well. Supplementary.
In this matter,
have you served the
challenging
affidavit and reply both? Have you served both?
Millard, yes, Millard. Yes. Supplementary affidavit and Millard affidavit in reply. If Millard wants to take up today, Millard, or Millard, kindly report that we have filed, Millard can take it up. Any other day will give them a notice and come back.
Have you taken leave to file the supplementary affidavit?
Yes, Milad, we have taken leave, Milad, but that Milad I am being told.
The order.
Or Milad, kindly grants me leave, Milad, I have already served on them. These are the subsequent events which has taken place after the petition has been filed. I have already served on them. Then Milad, kindly grant me that leave. I was told Milad, this is being taken, the leave has been already obtained.
Now, who is for the state?
I don't
On
find
it by
them.
chat.
But the issue is Milad, pertaining to Milad, the registration of Milad my deed of conveyance with regard to a commercial space Milad that I have obtained. Now, Milad, initially Milad, I have paid the entire money way back in 2013. The sum of it is 23 lakhs and odd. Now, Milad, at that point of time, Milad, it was Milad freehold land, whole of Milad sale. Milad, subsequently, I pay off the entire money. The policy decision, alleged policy decision has come, which Milad, they has now say KMD that they will not Milad make it Milad outright sale, but Milad, it will be converted into a lease. This is the issue. Milad, I have paid before a lordship Milad a direction on them to execute the Milad my deed of conveyance. This is a small issue pending before a lordship.
No
I have
affidavit is in place. No affidavit by the state.
Milad, affidavit in opposition has been served on us. I think Milad, they have not filed in a lordship court. That's the difficulty. Might we kindly keep it any other day? We'll give them a notice. Milad passes an order and Milad in that regard. Passes an order.
Ready.
Recording their absence and Milad.
None appears on behalf of the state authority. Petition is directed to serve notice upon the state authority. No? KMDA. KMDA.
Milad, kindly record that I have filed my reply. Milad.
No, you file on that date. Okay. You know. Upon KMDA. Let the matter appear in the list under the heading of to be mentioned. Under the heading to be mentioned on July 17.
July 7. Okay.
Yes.
Okay.
Next.
7 for the petition. The petitioner alleged about the non-payment of compensation on account of acquisition of his land. But in this context, petitioner made a representation before the authority concerned, including the district magistrate of the concerned district. But till date, his representation that has not been considered. Neither they say that land has not been acquired, or nor they deny that after acquisition he has not received the amount of compensation about the.
Have you received the amount of compensation?
No, nothing. Not
received.
Not a notification for such acquisition has been received by the petitioner. Whether from the document of the government itself, it is evident that land was acquired by the state government.
Where is your representation?
Kindly come to page 87. 4th of March 2022, I made this representation before the authority concerns. including the district magistrate of Howrah. Thereafter, I filed this writ petition.
Yes.
Well, kindly come to page 65 of my writ petition. This is an indenture between the
65.
65.
What is this?
But this is an indenture, my lord. It is executed between the governor of the state of West Bengal and the West Bengal Industrial Development Corporation Limited.
Yes.
It executed in 2012, my lord. And my lord, kindly come to page 68. Paragraph 3 from top, my lord. Paragraph 1. The first paragraph at page 68. Well, they have clearly stated that in the recital that under section 6 of the said act.
What are you reading? Page 68?
Page 68, first paragraph, my lord.
Under section 6 of the act, bearing. Yes. Read out.
Under section 6 of the said act, bearing number such and such, dated such and such, in respect of the said land, were duly published in the Kolkata Gazette, extraordinarily dated such and dated such and such respectively. Now the second paragraph, my lord, and whereas the collector of the Howrah district, having duly held an inquiry, made an award under section 11 of the said act for payment of necessary compensation for acquisition of the said land.
What is the land? What is the land involved here?
Yes, my lord. But in my representation, I have mentioned, my lord.
Land. Yes, land.
Plain.
Area of the land.
144 RS. Already accurate.
Yes, I am not disputing. I am claiming the compensation without
Plot number.
My lord,
What is your plot number?
my lord, 144. The last column, my lord, at page 69.
144. So who are you? You are, what is your name?
I am the
Are you the
successor.
recorded owner?
My lord, I am the successors. My predecessors in interest, he was the recorded owner.
What is the name of your predecessor?
My lord,
Where is the record in the name of your predecessor?
but initially it was in the name of Ganomoyi Manna. Thereafter, the Ponchanon Manna came into record, and the petitioner, he is the heir of the Ponchanon Manna. He is one of the sons of the Ponchanon Manna.
Where is the record of Panchanana Manna? It said Panchanan Baur.
No, my lord. Baur, my lord, Ganomoyi Manna purchased the land from one Ponchanon Baur.
Panchanan Baur.
Yes, my lord. I have annexed the deed, my lord, at page 14, 1-4.
Okay, Panchanan Baur was the recorded owner.
Yes, my lord.
Yes.
Lord, I think, my lord, regarding compensation, my lord, is the my lord subsequent purchaser. My lord, I am not on that. My lord, that is, when he is claiming that no compensation was paid, even if award be passed. My lord, so far writ code is concerned, my lord, kindly consider first page 23. No.
Yes.
My lord, this is after, no, before that, my lord, kindly come to page 65. First, 65. Then, that is 5th, 17th day of December 2012, Governor of West Bengal and the West Bengal Industrial Development Corporation.
Yes.
My lord, kindly see Governor, my lord, page 67, last line, last paragraphs, whereas the governor provided for acquisition and notification number section 4 of such and such, followed by declaration, section 6, and my lord, in respect daily public question of 12, 13, 12 respectively, whereas collector, however, is having the inquiry award under section 11 of the said act for payment of compensation such and such. And the collector district a sum of rupees at the cost of acquisition and rupees administrative for acquisition of land. Whereas the collector has accordingly made payment compensation to the awardees concerned and take possession of section 16, which therefore vested absolutely in the FIFA work. So, my lord, as soon as my lord knows that 16 comes, my lord, unless vesting is challenged, because there is no challenge of regarding vesting. So for this reason, first point, my lord, rightly, wrongly, even for argument's sake, but the prima facie
Award has already been given.
Prima facie award was passed, compensation was paid to the award. And my lord, this is, my lord, the presumption always, my lord, this is not between the two private individuals. And some leeway, my lord, because, my lord, this is after all government. But I think, my lord, nothing is treated to be a malafide or something like that, or no acquisition was made. Even in spite of that, it was recorded.
He must be informed.
Yes, my lord,
He
but
must
my
be
lord,
informed.
my lord knows that the person concerned at that point of time, my lord knows that awardee, section first award, so far Act 1 is concerned.
Yes.
Then section 16, position,
Yes.
compensation composition. So, as per the averments made in the documents between the two government entities, that awardee's concerned compensation was paid and taken position, and land was vested to the state. My lord knows that it is written in the act itself in section 16. And my lord, once it is vested, it cannot be divested unless the court set aside the. There is no question regarding
No,
setting aside.
is there any such prayer? He
No.
just prayer for consideration.
Only consideration.
But I am
Yes.
not asking for any
Divesting or
I am asking for compensation because my land has been notified.
no, whether compensation has given to you or your
Your
predecessor.
predecessor,
May
maybe,
That
my
has
lord,
to look
because
into.
yes, well, that is the.
May I pray one
Okay.
thing? Let my representation be relegated to
Okay. I'm directing you. Who is the?
My submission may be recorded.
Okay. So
Madam,
who is the person? Respondent number.
District magistrate.
Number 2 only.
Respondent number.
Respondent number.
Respondent number 6.
6.
My submission may be recorded.
Yes.
Yes. That
Very
acquisition was complete, vesting was done. Now there is no prayer for vesting, quashing of the vesting. So,
No, I am not challenging the.
an awardee, whether compensation was paid to the awardee. Whether I do not know right now, whether the erstwhile, because he has purchased.
Okay. Very good. Please take down. one Panchanon Manna, comma, within bracket deceased. Whether Panchanon Manna is alive or deceased?
Deceased.
Deceased. Deceased. Father of petitioner was the recorded owner of RS plot number 144 within bracket LR 141 situated at Moja, Jala, Vishwanathpur, jail number 5 within the jurisdiction of Pachla police station under district Howrah. Full stop. The said land was acquired by the government on indenture was executed between the governor of the state of West Bengal and West Bengal Industrial Development Corporation Limited on 17th day of December 2012, by which the collector by which the land was acquired by issuing specific notification. Collector of the Howrah district was given authority to make make payment of compensation to the awardees whose land was acquired. Full stop. It is the contention of the petitioner that he, being the successor of the recorded erstwhile recorded owner, never received any notice from the department, as well as no award was made, no compensation was made to him. Accordingly, he made a representation to the authority on March 4, 2022. The respondent authority sit tight over the representation, hence this date. Learned counsel appearing on behalf of the state authority submits that the government has already acquired the land. Notification under section 4 of the Act 1 of 2020 of Act 1 has already been published. By virtue of the said notice, the land has already been acquired. Collector of the Howrah district has made an inquiry and an award has been made under section 11 of the said act. The compensation were already made to the awardee, and the possession of the land had already been taken by the government of West Bengal, free from all encumbrances. Full stop. It is the contention of the learned counsel for the state that award has already been made to the all awardees. Compensation has already made to the awardees. So this writ petition has
And land is vested.
Land is vested to the state, free from all encumbrances. I have already policy order. কি বললাম বলো? the writ petition has no merit to stand up. Having heard the learned counsel for the parties, I and considering the indenture made between the government of West Bengal as well as the West Bengal Industrial Development Corporation Limited, it appears to be that the land in question has already been vested to the state, free from all encumbrances. Full stop. Whether the petitioner or the predecessor of the petitioner has actually received the compensation or not is to be determined by the concerned collector. Full stop. It appears that the petitioner has made a representation to the collector, respondent number, respondent number 6 of the instant writ petition. No decision has been taken by the respondent number 6 on the basis of the representation. Hence, I find it necessary to pass a necessary direction upon the respondent number 6 to dispose of the representation of the petition within a time-bound manner. Accordingly, the instant writ petition is disposed of, directing the district magistrate Howrah, being the respondent number 6 of the writ petition, to dispose of the representation of the petitioner dated respondent. What is the annexure?
Annexure P5, page 87, 4th of March 2022.
P being annexure P5.
P5.
P5 dated 4th of March 2022. Within 3 weeks from the date of receiving of the copy of this order, after giving a reasonable opportunity of being heard to the petition, decision of the authority shall be the respondent number 6 shall intimate the decision to the petitioner within 2 weeks thereafter. I make it clear that I have not entered into the merit of this matter. The respondent number 6 shall dispose of the representation according to the law without being influenced by any observation of it. Since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be have been not admitted.
I'm grateful, but I'm filing
Disposed
affidavit
of.
of service.
Affidavit of service Okay.
My lord, item number 4, my lord, 1230 fix. Item number 8, my lord.
For the respondent.
Item number 4, petitioner 6 accommodation. At the first instance,
My lord, then my lord, pass 2 lines order, my lord.
I have already passed the order.
Then I was not there. My name.
You gave your name. You gave your name. I have already passed the order.
That's why, my lord. দিচ্ছে না তুমি
Lord, I am appearing on behalf of the petitioner in this item number 8, my lord. This is a matter regarding the
item number 8.
8, my lord. I am appearing on behalf of the petitioner. This matter is regarding the encroachment of the state highways of land, my lord. My representation is page 13, my lord. That my blocking my ingress and egress one.
What is the matter about?
Permanent construction has been raised by encroaching the state highways land, my lord. My lord, after filing the writ petition, my lord.
তুমি বলতে পারোনি।
No,
My
no.
lord, this is a case where the petitioner is seeking for removal of encroachment from government land or PWD land, which is earmarked for highways.
Okay.
And he had made a representation to that effect, and they have worked.
Who are you?
I am petitioner, my lord.
You are
The
residing
petition-
where?
Adjacent plot owner, my lord.
Adjacent to
plot,
the
my
government plot.
Yes, my lord. There is big plot, my lord. Some plot has been encroached by the highway, and the rest portion is remaining, my lord.
And who are
my lord? His private.
Whose land?
My lord.
Whose land there is encroachment?
That is
Suppressing
highways
the
land, my
title suit filed by
That
the
is
petitioner. But the writ petitioner made a similar.
my lord.
by
My lord,
petition.
I think, my lord, I am the petitioner, my lord. Let me finish.
Just wait, madam. Just wait, madam. Let me Understand this issue? I cannot understand. So what is your plot number?
My plot number is, my lord.
What is your plot number?
My plot number is, my lord, starts in page
10.
2 and 3, my lord. Petition number, my lord, paragraph number 3, my lord. My is annex, my lord, and my page 10 is the annexure P1, my record of rights.
Yes, page 10. Page 10 is a record of right. So plot number is 597.
597.
So your name is
Anil Kumar.
Anil Kumar Midde. Very good. So you have 14 days. Okay. So what you want? So which plot, which portion?
Same plot number, my lord. Some portion has been encroached by the petitioner, my lord.
Who encroached?
Private respondent, my lord.
Name? Respondent number 6.
5 and 6.
5 and 6.
6, my lord. From the picture, it was very much clear, my lord. Next page, page 11 is a picture, my lord. Photograph of the construction, my lord. And
page 11 is the photograph of construction.
Photograph of the spot, my lord. Adjacent property is mine.
So
kindly
in the photograph, I see one shop room, some
shop room, and including, my lord, one brick wall has been.
Where is the brick wall?
That is, my lord, behind the.
Before. Before that.
Which plot is this?
That brick wall has also been constructed by encroaching the highways property, my lord.
Which plot is this? Highways property?
That is highway land, my lord. My lord, kindly after understand, my lord. After filing of the during the pendency of the petition, assistant engineer Ulberia 1 approached the.
It is the PWD department.
PWD department. Kindly see that, my lord. 10-1 has been already been issued, my lord. BLRO, from the report of the BLRO, it is evident that the property has been encroached by the private respondent. And 10-2 notice has already been issued, my lord. But 10-3 is.
What is this? Demarcation of land, government land adjoining. This is the orders of assistant engineer. PWD.
First, my lord.
Have you served these documents?
Yes, my
Lord, I am appearing for the statement.
Served to me, my lord, during the pendency of the petition, my lord.
You have served all the documents to the petitioner, to the respondents. Have you served all the documents to the respondents?
He has served upon the state right now. I am appearing for the state.
No, my lord. First document is the document for the assistant engineer.
No, these are the extraneous to the writ petition. You have to file by supplementary. Not like that. How can you file like that, these documents? Document. So what is your prayer now? What is the writ petition?
Removal of the encroachment.
Removal of the encroachment. So who is the authority? You are appearing for the state.
I am appearing for the state.
What is my lord?
I understand.
Let me clarify the interposition. In terms of section 10(3) of the West Bengal Highways Act, the encroachment has to be removed by, if it's found everything is in order, then it has to be removed by the subdivisional officer of the district. But my learned friend, he has not made the subdivisional officer a party. So it cannot be enhanced without making a party and serving a copy upon him. I cannot seek for instruction unless he's made a party in this particular place. So that is only one lacuna. Otherwise, what documents he has given, it shows prima facie that there has been an encroachment. But this has come from my learned junior friend here, so I cannot vouch that is okay. I need to get it from the appropriate authority, which I do not have right at this moment. Once the subdivisional officer is in CC over the entire matter, he will have to tender a report to me. I can place it with your lordship.
Who is the authority? Subdivisional officer.
Subdivisional officer, and he has not been made a party in this particular writ application.
Okay.
Without that, 10(3) of the West Bengal Highways Act cannot be given effect because he's not a party.
My lord, may I, my lord? This happened during the pendency of the writ petition, my lord. When I am filing this writ petition, section 10(1) has not been complied with, my lord. I have made a representation before the assistant engineer. According to the section 10(1), he has to issue a 10(1) notice to the private respondent to remove the property. But my lord, that was not done. So at that moment, my lord, there is no scope to make a party to the subdivision officer, as because 10(1) and 10(2) has to be complied with. After that, the role of the subdivision officer comes, my lord. Now, during the pendency of the writ petition, they have served some notices to me.
So you come with the supplementary, otherwise it will hike out.
I'll tell your lordship what my learned friend is doing. He's become Kalidasa. He's sitting on the same branch on where he's sitting on the branch, he's cutting it. He says the first part was not done, so I filed the writ petition. Now the first part is already done, so writ petition is no more maintainable. If he says that, the writ petition is gone.
Very good. So what is the private respondent? Just let me see private respondent.
I'm actually for the private respondent number 5. But I feel it tried to file this writ petition while he approached before the civil court by filing a title suit, thereby claiming seeking declaration and permanent injunction. By not getting any injunction, any protection over the property manner, then he made this writ petition with the self-same prayer manner. And that suit manner is very much contested by the private respondent. On self-same cause of action, upon the self-same property, they made this title suit which is still pending. And when they have not received any injunction, they filed this writ petition, and now they are seeking the same remedy to demolish my construction over the property. And in between, my lord, an inquiry made by the BLLRO, my lord.
Dealer pressure. No.
Yeah, okay. This is a 2022 report, my lord. In respect of an application under section 144 of the CRPC, this report made by the revenue officer.
You just read it. I can understand.
Only one comment. It's written in Bengali. No, it's in English. As per your instruction, a field inquiry has been done over the plot number 597 of Mouja Roll Shala
597.
number such and such manner. At the time of inquiry, first party Anil Kumar Midde, son of late Ramesh, and second party Narayan Chandra Midde, son of late Sudhir Midde, were present at the spot along with relevant documents. Some local people were also present at the spot. It is found and came to know from the local people that Anil Kumar Midde and his wife, Srimati Apurna Midde, have not in possession over the suit plot, though they are recorded owners of the suit plot. On the other hand, it is came to know from the present local people. Present means at the time of inquiry, some local persons were there. Present local people that Narayan Chandra Midde, son of Sudhir, possessed the suit property, a suit plot area since long time ago to till date. But both the petitioner and the respondent, they are the relatives with each other, and they are the co-sharers with each other. Now it is their private dispute, and suppressing the fact that they have already approached before the civil court for declaring the title, whether the petitioner or the private respondent, who is actually over the title of that particular plot of land. He made this writ petition, and now they are trying to demolish the construction of the petition respondent, which is at present possessing and enjoying.
Okay. So I
Oh,
understand.
Malad,
No,
Malad,
just
that-
wait.
that-
Just wait.
let me
The issue is that one civil suit is pending. Civil suit is between the two private parties. So private parties may fight each other with the civil suit before the
Exactly.
civil court.
Exactly.
Now, in the writ petition, no, in the writ petition issue is different. Issue is that whether any encroachment is made
On PWD land.
PWD.
Correct.
This is the only issue here. Whether your construction is not, whose construction is, this is not the look into the only issue is that whether there is encroachment over the PWD road
But the
by a
issue is
person.
same, Mala, because in the
No
title
issue
is Mala,
between the private person, not upon the any government land.
he is claiming
So
the title
now-
over the same property, and over the same property he is claiming that property belongs to the government.
Let the authority be decide.
Malad, we have decided on the issue. We have decided to a fair extent in the issue. I'll just read out.
No, whether
It is on highway land. The assistant engineer, he has given a report on 22nd of February 2023. I'll just read it to your lordship for convenience. As per report received by the BLN Ilaro, Uluperi, I mentioned so and so. I've observed that Narayan Chandra midday has made a permanent structure encroaching government land on LR plot number 597 RS plot number so and so. As a result, he has been liable to prosecution as per the West Bengal Highways Act 1964. A notice under section 10(1) of the West Bengal Highways Act 1964 has been issued to the encroacher via memo number so and so. But the encroacher has failed to remove the encroachment from government within stipulated period of time. Hence, you are hereby requested to take necessary action as per section 10(2) of the West Bengal Highways Act 1964 and deliver the possession of the alleged land to the undersigned. This is by the assistant engineer to the subdivisional officer. Yes.
So the authority has already taken steps.
Yes, but the subdivisional officer is not accessible here because he's not made a party respondent out here.
He is here for the not considering his representation. As you have already considered his representation and initiated steps by taking a proceeding by memo number such and such. So it is not necessary to continue the repetition now.
Kindly pass a direction to the subdivision office. I can make a party with this.
No. Now these are the all separate issue altogether. You are here before this court that your representation were not considered. They have already considered your representation.
For consideration of
And initiated the proceeding. Let them proceed with this. I can direct to conclude the proceeding according to the law within a specific time frame.
Yes.
That may be directed. Who is the authority? Who is the perfect authority? Correct authority? They will decide. This
Is
not
the
issue.
subdivisional officer, Malad?
Yes, that is not the issue here. Very good.
According to the section
That report, Mala. As per my information, Mala,
Have you received that report? Yes, Anil Kumar Midde. Who is Anil Kumar Midde?
No.
Petitioner. No, whether any notice was served upon the encroached person who encroached the.
Yes.
This is the
Anil Kumar midday is there. Oh.
No, one Narayan Chandra Midde has.
Yes.
Encroachment. This is the order.
Yes, as per report, it has been observed that Narayan Chandra midday.
I am passing the order to serve you. I am passing the order to serve you.
কিন্তু এইটা তো এসডিও কে বলেছে
allowed to participate in this.
if they aggrieved they have if they aggrieved by this there is a provision for appeal they can prefer an appeal. I don't need to tell them what is to be done.
Given to the respondent number 5, that I don't know because it is clear from this order, Mala, that order has never been communicated to the Narayan Chandra.
Very well. You have the opportunity to challenge that order.
Mala.
Okay, you can challenge it. Please take down.
Yes, absolutely. It's a challenge for it. বললাম তো চ্যালেঞ্জ করে দাও আমি রাস্তায় রাখলাম
Petitioner is the recorded owner of plot number 597 of Mauja Dol Salap under PS Uluberia district, Howrah. Full stop. It is the contention of the petitioner that private respondent number 5 and 6.
5 and 6.
Has encroached the government land, belonging to the Public Works Department,
Uluberia.
and made some pakka construction therein. By such some portion of the land of the petitioner has also been encroached. He made a detailed representation to the concerned Chief Engineer, Public Works Department. Chief Engineer, respondent number 2, bracketed respondent number 2, but his representation was not considered. Hence, this writ petition. Learned Counsel, appearing on behalf of the private respondent, submits that the petitioner has also approached before the civil court in appropriate civil suit by filing an appropriate civil suit seeking injunction thereon against the present petition, against private respondent. The learned civil judge did not issue the order of injunction. Hence, on the same issue, the instant writ petition has been prepared. Learned Counsel, appearing on behalf of the respondent authority, submits that with written instruction that that Assistant Engineer, Uluberia Highway Subdivision,
Public Works Department.
Public Works within bracket Road Department has already
issued a memorandum.
Has already taken note of the representation, and one inquiry was made by the concerned BL and LRO Uluberia in respect of the disputed land in question. By such inquiry, a memo was forwarded to the subdivisional officer Uluberia subdivision. By memo dated 22/2/2023. We placed the Learned Counsel for the respondent authority placed the memo. For the proper determination of this matter, the contents of the memo is set out as follows. Full stop. If further some Learned Counsel for the authority concerned has further submits that as the respondent authority has taken the decision, has taken the initiative on the basis of the representation of the petitioner. The instant writ petition has nothing to decide. Nothing left in the writ petition to decide. Learned Counsel, appearing on behalf of the private respondent, submits that no notice has been served upon the private respondent before making any inquiry or inspection over the plot of land. He further submits that the concerned BLLRO has already submitted a report before the executive magistrate in terms of an proceeding under section 144 within bracket 2 CFPC that the private respondent are in possession over the plot of land. Having heard the Learned Counsel for the parties, it appears that the grievance of the petitioner is for not consideration of his representation made to the Chief Engineer Public Works Department. Public Works bracket Roads Department. It appears from the memo as placed by the learned counsel for the respondent authority that the concerned assistant engineer of the department of PWD roads has already initiated a proceeding and referred the same to the subdivisional officer Uluvedia subdivision. Considering the conduct and action taken by the assistant engineer PWD roads, Uluvedia highway division, Uluvedia highway subdivision, it appears that the grievance of the petitioner has already been ventilated to the upper authority by making necessary inspection. Full stop. Thus, the instant date petition. So, under the above objection, the instant date petition. Instant date petition. No, thus there is nothing to decide in the instant date petition. Full stop. I make it clear that the representation of the petitioner has already been considered by the authority. Thus, there is no merit to pass any further order in the instant date petition. However, I make it clear that the petitioner as well as the private respondent has their available remedy before the appropriate authority, according to the law, in respect of the proceeding initiated by the respondent authority and forwarded the same to the subdivisional officer. At the same time, the private respondent has the remedy in law to challenge the proceeding before the appropriate forum.
District magistrate.
Appropriate forum.
Yes, section 10(4).
Yes, considering the same, the instant date petition is disposed of. Okay, I further make it clear that if the proceeding has already been initiated, as the proceeding has already been initiated and referred to the subdivisional officer concerned, the subdivisional officer shall dispose of the proceeding in a time-bound manner as enshrined in the law itself, after giving a reasonable opportunity of being heard to all the parties concerned.
No, grateful. Disposed of.
Disposed of.
In 9, I appear for the petitioner, my lord.
But I appear for the ADDA.
My lord, just today, a few minutes ago, I have received a copy of the report filed by the learned advocate for the state. Kindly take it after 2 weeks because I want to go through it and take instruction from my client on the basis thereof.
Where is the report? Give me the report. Have you received the copy?
Yes, just
okay.
Some time ago.
Okay, please take down. In pursuance to the direction of this court dated June 27, 2024, State of West Bengal, being the respondent number. One.
State of West Bengal respondent number?
Not one.
Not one. One is Asansol Durgapur Development Authority.
State of West Bengal is respondent number 3.
Respondent number 3. being respondent number 3, has submitted a detailed report through learned state advocate. Full stop. Copy of the report has already been served upon the learned counsel appearing on behalf of the petitioner as well as learned counsel for ADDA. Full stop. Next, petitioner 6, accommodation to submit exception.
Yes.
Exception to the report. Let the exception be filed within 2 weeks. Within 2 weeks hence. List the matter on 25th of July 2025. 25th of July. Report filed by the state authority be taken on record.
Okay. 25th. What do you mean?
Somebody there.
Applying for the state respondent, there must be a junior of Mr. De. On the earlier occasion, your lordship was pleased to take up the matter when Mr. De was not present, but I have informed him in terms of your lordship's direction. I have informed him.
Where is Mr. De? Yes, what is the matter?
Yes, Lord, just Lord, to cursor the matter, Lord, I am just Lord, here I have alleged, Lord, some encroachment of government land classified as Noyanjuli, which was converted to a Pakka building construction market complex by the private respondents. Initially, Lord, in 2021, a writ petition was filed, wherein, Lord, this Honorable Court was pleased to direct the concerned authorities to take up the proceedings under Section 10, your Lordship knows, under Section 10 of the West Bengal Highways Act. Lord, that proceedings was ended with the order of the learned subdivisional officer, and thereafter, Lord, the private respondents prepared an appeal. In the appeal, the learned district magistrate, Lord, dismissed the appeal with a direction that the entire constructions made over there to be demolished, and Lord, the original position of the Noyanjuli to be restored. It is besides the highway. This Noyanjuli is besides the highway. Lord, that portion is ended by passing the order by the learned district magistrate. They never challenged the order of the district magistrate before this Honorable Court under Article 226 of the Constitution of India. But the authorities did not take any steps to comply with that order. I filed the present writ petition before your lordship for implementation of that order, because, my lord, in spite of existence of that order, my lord, the concerned authorities did not take any steps to demolish the entire illegal construction of market complex situated over the Noyanjuli.
Have you served private respondent?
Yes, on the earlier occasion, private, this matter was heard, my lord, considerable period when, my lord, the learned advocate for the state respondents as well as the private respondents present. Your lordships kindly have a look of the last order. I am showing to your lordship's order. When your lordships kindly have a look of the order dated 25th August 2022, passed by this Honorable Court in the present writ petition. Your lordship will be clear. Today, my lord, I am not moving the motion. Today, I have to, my lord, submit before your lordships about the report submitted by the state authorities, because the state authorities was
order you are referring,
Lord, 25th August 2022, passed by the Honorable Justice Subra Ghosh.
25th August 2022. Yes.
Yes, your lordship has got it. Affidavit of service filed on behalf of the petitioners is taken on record pursuant to an order passed by this court in WPA number 3998 of 2021, which I am just referring to, your lordship, earlier petition. On 13 September 2021, proceeding under Section 10 of the West Bengal Highways Act was initiated by the state respondents and brought to its logical conclusion by order dated 22nd February 2022 under Section 10(4). that is the landed district magistrate of the act. Landed counsel for the petitioner submits that it is recorded in the state order that an area measuring 10431 square link on the plot of 38. This 38 plot is the government land and classified as non-juri of Mouja so and so upon by the private respondent, but the compliance report submitted by the respondents on 27th May does not indicate that the entire encroachment was removed, demolished by the authorities. My submission before Lordship that 10,000 plus link construction was not demolished, which was specifically earmarked by the landed district magistrate. Then Lord Learned Counsel for the state respondents in his usual fairness submits that compliance report is not in form and a fresh report is required to be submitted. In view of the same, the matter is urgent. State respondents are directed to submit report in the form of affidavit disclosing whether the entire encroachment as stated in the order dated 22nd February 2022 by the district magistrate Purvamindapur has been removed or demolished. Let the matter appear so and so and so. After this order was passed on 25th August 2022. After this, Lord, they have submitted one report before your lordships. Your lordships kindly have a look of the report. This affidavit was affirmed. This
report in the form of affidavit.
Yes. Report in the form of an affidavit. This affidavit was affirmed on 20th September 20.
Yes.
20th September 2022. Your lordships kindly see the contradiction of two reports. First report, next page. Report of the assistant engineer. Kindly see. Court says that no encroachment was not removed. Assistant engineer says encroachment has been removed. Kindly see this. Second paragraph. In compliance of the WP number so and so, earlier writ petition, not this writ petition, 3998. The total area measuring so and so demarcated by the so and so, white so and so, total encroachment removed from the aperture area and compliance report submitted. But the Honorable Court has said on the subsequent matter that was not removed, but the assistant engineer says that it is removed. Kindly see. After completion of removal, again, they encroach some portion of the kindly see. Then, your lordships kindly come to the last paragraph. On 15 September 2022, demarcation completed as per report of the BLRO, contact 1, byte number so and so, the undersigned served notice so and so. Again, my lord, they started 10-1 proceedings. Without complying with the earlier orders, again they have started. Then, my lord, your lordships have a look of the contrary report submitted by the block land and land use officer on 19 September 2022. Lord, in that document, Lord, it was not paginated. That's why, Lord, this document, I'm just showing to lordship this document. This was report passed by the block land and land use officer, enclosed with this report. 19 September 2022. Just not 4-5 pages thereafter. It was not paginated. That's why, Lord, I could not. Has your lordship got it?
Dated.
19 September.
Yes.
Yes, sir. Marriage. Now, this report was submitted by the block land and land use officer to the assistant engineer. What he says, can you see? In compliance with the above cited subject and reference, this is to state that a physical inquiry cum demarcation of PWD land, LR plot number 38, area measuring 10438 square link, jail number so and so, Mouja so and so, in front of so and so, has been conducted by the office of the undersigned in presence of the petitioners and respondents and representatives of your office. That means not the assistant engineer's office. According to the LRROR, the said area of the suit plot number 38 classified as non-Julie recorded in favor of PWD roads. From the inquiry report of concerned RI, it reveals that currently there is no existence of non-Julie due to concrete casting. Kindly see, there is no existence of non-Julie due to concrete casting on the surface of soil and various types of illegal construction like drain, tank, wall, stalls, sloping stair, etc. made by brick, cement and concrete. Kindly see, this is not one day work. And thereafter, who has done this? This illegal construction have been made by the respondent Sri Kamal Das, son of Sudhir Das, who is the private respondent herein. There is a tea stall of Sukumar Das, who is also a private respondent herein. And a Xerox stall, namely Bholanath Xerox of so and so. Both stalls are made by brick, cement, and concrete, etc. Hence, the inquiry report of so and so, so and so, so and so, so and so. So till date, in spite of direction of this honorable court directing to demolish the entire 10,431 square link construction over the Noyanjuli, that was not removed, and the particular land was not come to its original position of Noyanjuli. But they are saying that we have done. Each and every time. On the earlier occasion, your lordship has seen that there was a report submitted by the state authorities in the order mentioned.
Where is the report?
No, that report, I don't know. They have not served any report, but the order says that. Just now, which order I have placed? 25th August. 25 August, kindly see the order. That report was submitted before this honorable court on 27th May 2022. Order records that.
Report was returned back.
Yes, because it was not in proper form.
Not in proper form.
Yes. That report goes. Thereafter, this report filed with this situation. Assistant engineer is saying that we have removed. BLRO is saying that there was a concrete construction.
No, assistant engineer says in the report that earlier in pursuance of the order of the district magistrate, the removal has been made.
No removal has been done because of the view that no removal has been made because of the view that this matter was coming from the earlier petition.
You read the report. Whatever you miss the middle paragraph. In the meantime.
No. Yes, I have seen Milord. In the meantime,
yes.
So filed the case now so to comply with the order so the undersigned sent request letters to BLR Contai for demarcation of land, identity of enclosure so and so and so. But your lordship kindly consider in the earlier writ petition, that is, Milord, the earlier writ petition is number 3998. Yes. From that writ petition, Milord, till date there is no report submitted before your lordship that the entire encroachment gone. Only the paperwork. Yes, said in the paperwork. That's why, Milord, the next writ petition, I had to file the next writ petition because of that. If it is demolished and it is restored to its original position, I should not have filed the.
It is the order of the district magistrate.
Milord, yes. In the writ petition, I have a next. In the writ petition, I have a next. Your lordship kindly have a look of the.
Mr. They has to be heard in this matter. Otherwise.
Yes. It requires. It requires.
Milord. As you have raised some point of discrepancy in the report itself.
Yes.
So, Mr. They has to be heard.
আসুন বলবেন এখন নেই তাহলে আপনি কথা বলছেন কেন? Milord, your lordships kindly have a look of the report of at page 61 of my writ petition. This is the order of the London district magistrate.
Very well. I hear Mr. I want to hear Mr. They on this matter. Very well.
Well, kindly direct Mr. They to be remain present on the next day. On the earlier occasion also, your lordship directed me to communicate your lordship's order or direction, other direction. I have communicated him.
Very good. Petitioner raised some doubt regarding the report submitted by the concerned authority before this court. He further submits that the report is totally different to the report when it was report which was placed before this court on the earlier occasion on
27th. Milord, the earlier report.
on 25th of August 2025.
That is the order passed by this honorable court.
25th of August 2022.
Earlier report was submitted by this honorable court on 27th May 2022, which was not informed.
Okay, কি বললাম? 27th of May 2020.
Which was not informed and thereafter were directed to file a fresh.
May of 2020. 27th of May 2022. Full stop. Concerning the submission, it is required to hold the learned state advocate on that point. It is the further contention of the petitioner that no steps has been taken by the respondent authority in terms of the direction of the concerned district magistrate regarding removal of encroachment.
And we are also
over
told
the
the direction of this
Nayan
honorable court.
over the Nayan Julie beside the government land.
And not in terms of this honorable court on passed on 25th August. That was not also complied with.
Full stop. Concerning the same, let the matter appear in the list on 17th of July 2025 under the same heading. Full stop. Petitioner is directed to serve notice upon the learned counsel appearing on behalf of the respondent authority and file an affidavit of service on the returnable date.
I am grateful to your lordship. বলতে সত্য হবে মনে রাখবে।
ছোট মোটো ছিল আপনার সঙ্গে যায়নি তো? এটাতে সবকিছু লেখা ছিল, সেটাই পাওয়া হয়ে গেল।
Yes.
Judgment গুলো বের করুন। হ্যাঁ, on the last occasion, I stopped.
Yes.
With regard to making of submissions, that one important aspect that if the notice goes vesting goes, I have filed the single bench judgment which was upheld in special bench judgment, and ultimately it went up to Supreme Court. Supreme Court upheld the decision of the single bench. Now, on this point also, my lord, what will happen if the notice goes? Another judgment, my lord, another judgment I want to submit before your lordships. That is reported in 2013, just 2013 volume 1, Mondo, CHN 444. পেলি না তো? আমার নোট ছিল ওখানটায়, কোথা থেকে ধরো কাগজ হয়ে গেল। না আনতে হবে না, ঠিক আছে, এখান থেকেই করছি, মনে আছে, ঠিক আছে। This is also on the same point.
Yes.
If the notification goes, kindly, I will not much trouble your lordships. Kindly come to para 47. Para 47. Here, my lord, I am not going so details. What happened in this case after these, my lord, amendment of the West Bengal Act 2 of 1948, 94, 97 by which 96 Amendment Act, then there are Land Acquisition Amendment Act 1997. My lord, 7A was introduced, proceedings to lapse.
Yes.
Now after that, government tried to save these vestings by passing another law, that is Land Acquisition Validation Act 2011. That I have not, that copy I have not handed to my lordships. With that reference to that act, this judgment has been passed. So ultimately we will take the decisions of this court. Kindly come to para 47.
Yes.
Whether, my lord, these lapsing notices can be validated. That attempt was made by another act. That will, your lordships will get that in para 46. It is significant to note that the validation is conferred to, I am not saying that is 2011 Act 47. There is no question of validating any lapse proceeding under section 7A of Act 2 of 1948, and by no imagination that 2011 Act, having its retrospective commencement of 1st April 1997, can be said to have revised and validated an acquisition which has lapsed on or before 31st March 1995 by operation of section 7 of the 7A of Act 2 of 48. Exactly our case, we have said that since the notice was published prior to 2 years before commencement of 1994 Act, Amendment Act, so award ought to have been published within 1 year from the date of commencement of 1994 Act.
Yes.
Here in this case, it was published in 1980, so that provisions will apply. In that context, it is held that can be said to have revised and validated an acquisition proceeding which has lapsed on or before 31st March 1995 by operation of section 7A. So in our case also, the proceedings to lapse by virtue of section 7A, there is no question of revalidating this. Then what will ultimately happen? Then we will kindly come to para 51. Para 51, next page. In view of lapsing of the acquisition proceeding under section 7A of the Act of 1948, the title of the original are revived. This is most important. What I want to say, as soon as the proceeding left lapse,
title of the original owner revived. We have approached this court, so after 31st March 1995, our title revives. Even if any portion of the land covered by the notification issued under section 4(1)(a) was transferred subsequently to any third party, namely in favor of one of the present appellant petitioner, then also after lapsing of the acquisition proceeding, title of the original owner would revive. The subsequent purchaser and the original owner will thereafter be entitled to work out their respective rights in this respect of the said land. We are not inclined to decide the same of this stage at this stage, since it is beyond the scope of the present appeal. So, my lord, what it says clearly, title after lapsing of the 4(1)(a) notice, title of the original owner revives. So, our title in the land revives on 31st March 1995 after the lapsing of the notice under section 4(1)(a). Ever unreported judgment of my lord, this is an appeal Supreme Court. ওদেরকে কপিগুলো দিন, ওদের কপিটা দিন। My lord, this matter went up to Supreme Court. Or this is the unreported copy, my lord, went up to Supreme Court. One important aspect also is to be considered by your lordship.
Which matter? This matter? No.
This matter.
Okay.
This Mondodari Bhakot reported in 2011 13(1) CHN Calcutta 444. 2013-1 CHN Cal 444. Just I have placed.
Okay.
That matter went up to Supreme Court.
Very well.
But that is this unreported judgment. Your lordship kindly see. Your lordship will get it. Petitions for special leave to appeal number such and such arising in the impugn of final judgment and order dated 17th October 2012 in matter number such and such passed by the High Court at Calcutta, State of West Bengal and others versus Mondodari Bhakot. Then you will kindly come. Upon hearing the court, upon hearing the counsel, the court made the following order. Permission to file additional documents is granted in view of what has been recorded in our previous order dated 14 November 2017 and the report of the District Magistrate Paschim Bardhaman submitted pursuant thereto, which we would indicate that there is no mining activity on the land in question. We find no good reason to interfere with the order of the Division Bench of the High Court. All these special leave petitions are accordingly dismissed. It will naturally be open for the state or for the acquiring authority to take steps under the provisions of right to fair compensation and transparency in land acquisition, rehabilitation, resettlement of 2013. You also kindly marked it. At this stage, subsequently we come to that because we have also said, since the proceedings stood lapse, since the notifications stood lapse, if the government wants to acquire it afresh, they have to resort to the provisions of the right to fair compensation of 2000.
Present prevailing act.
Present prevailing act. That has been observed by the Supreme Court, if the government wants to appeal. আরেকটা এবার এইটা বের করুন, এটার কপিগুলোর দিকে দিন। মহাদেব খান ভার্সাস স্টেট অফ হ্যাঁ জাস্টিস টেন্ডার আসবেন ওদেরকে। Number in a single bench decision, all these পরে দিয়ে দেবেন না হলে। Number this Savitri Devi's case, then we got appeal in against that special bench judgment, these Mondodari Bhakot, etc. All these judgments are considered in a single bench judgment. Although appeal was preferred, we do not know the fate of the appeal. So, my lord, that judgment we will also, your lordship will also kindly consider. I do not want to read the entire judgment. Only thing it has been said, if the proceeding lapse, then the government is required to initiate proceeding under 2013 Act. Kindly come to last but one page of the judgment. That decision. Oh, sorry, Miller, kindly pardon me. I failed to hand over the copy of the judgment.
Yes.
Kindly come to last but one page. I do not want to trouble your lordships with similarly repeating what has been held, etc. Possession, everything has been considered. Now, to sum up, the notice under section 4(1)A of the Temporary Act lapsed on 24th of November 1995 like us. As no award was published within the time indicated in section 7 of the said Act, even the introduction of 3A and 3B of section 9 of 1894 Act does not save the lapse notices as they are held by the special bench in Savitri Devi's case. The notice claimed to have been issued under subsection 3B of this Act is void and illegal as it does not extend the period of lapse notice. Admittedly, the compensation has not been paid as yet and the requisition cannot continue after the expiration of the life of Temporary Act. Since the land of the petitioner has already been utilized for construction of the connector, it will be hardship on the state to revert back the land to the petitioner as the purposes still exist. The state is thus directed to take steps under 2013 Act within 6 months from the date of this order and pay the due compensation in accordance with the provisions contained therein within the aforesaid stipulated time. So here again, here only fact is this: here after the expiry of the notice, they wanted to invoke 9(3)B. Your lordship might remember that 9(3)B can be invoked as has been held by special bench in respect of those proceedings which survived as on 31st March 1996.
Yes.
In this case, the proceeding did not survive as on 31st 1997, but the government deliberately issued a notice under section 9(3)B. So that 9(3)B notice was also quashed with the direction that if you want to acquire it, you have to acquire it.
9(3)B means the time period has not been elapsed yet.
No, 9(3)B means, my lord, after the expiry of the Act 2 of 1948, another act was published by the state government called the Land Acquisition West Bengal Amendment Act 1997. Therein, provisions were made to complete the acquisition proceeding
by 31st March 1997.
No, by that 1997 Act, provisions were made to conclude the requisition or acquisition proceeding which could not be completed by 31st March 1997.
Yes.
By
That means,
31st March.
the time frame was there.
Time frame is already there.
Already there.
Time frame is already there. So, my lord, if they wanted to invoke, and in Savitri Devi's case it has been held that only 9(3)B can be invoked, where on 31st day of March 1997, the notification under section 4(1)A survived.
Not been elapsed, has
Has
survived.
been elapsed. Remember, kindly, it expired on 31st March 1997. Suppose in January 1997, a 4(1)A it survived. So, in that case, you invoke 9(3)B. But suppose if it more than 3 years before 31st March 1997, there is no scope to survival of the notification under section 4. That is the distinction. Now, my lord, we have challenged the validity of the award because both the awards are passed in violation of statutory violation of section 7A. So, my lord, in this case, this judgment your lordships will kindly consider that is reported in AIR 2007. Not on this point of vesting, on separate posting, whether we can challenge the award. AIR 2007 Supreme Court 1151 1151. It is at paragraph 6 at page 1153. Kindly come to page 1153. Left hand side, paragraph 6.
Yes.
But in this case, another judgment of Supreme Court has been considered in this paragraph, and ultimately paragraphs of those judgment has been quoted here. Your lordships kindly come to quoted paragraph 22 of the earlier judgment which was considered by the Supreme Court. Now what I am saying, my lord, the main contention that I will come later on. One is delay. Then, my lord, you have accepted the award by filing reference petition, etc., etc. Now, if the notice goes, then what will happen? Kindly come to para 22. My lord, first paragraph I am not reading. Kindly next sub paragraph at 1153. Similarly, as your lordships got it?
Yes.
Similarly, in HMT Housing Building Cooperative Society, 1995 3 SCC 128, in which the present appellant was one of the societies, my lord, which challenged the order of the division bench of the High Court of Karnataka, their lordships dismissed the special leave petition following the judgment in HMT Housing Building Cooperative Society, Supra. In paragraph 3 of the judgment, while dealing with the facts of the society, their lordships observed that the society had advertised the inviting person who want to have mansions in the city of Bangalore and had also given the names and addresses of the representative at Dubai. It was held that on the basis of the aforesaid material, the High Court has rightly come to the conclusion that the society itself was not bona fide house building society, and accordingly the order passed by the High Court setting aside the acquisition of the land was upheld by this court, and the Supreme Court and the SLP was dismissed. Paragraph 3 has been quoted. Milord, skip it over. Milord, now kindly come to 154. Milord, last sub paragraph. But first part, your lordships kindly skip. Right hand side, learned counsel. This is
yes.
Learned counsel for the respondents has also invited our attention that same notification was set aside by High Court, and the said order of the High Court was also upheld by this court by dismissing special leave petition such and such on 7th of April 1998 and SLP number such and such on 14th of July 1999 concerning the very same appellant society. In this background, this is important, when the acquisition has been found to be totally mala fide or not for bona fide purpose, the ground of delay and the acquisition in the present case has no substance. But two things your lordships kindly consider, because bona fide and mala fide, although we have said that on two aspects. One aspect is this: we have challenged the award; it has been passed beyond the statutory period of prescribed in the Act. Second aspect is this: is mala fide, that you have not utilized any portion of the requisition land or acquired land for the purpose for which it was sought to be acquired. So this is, my lord, the mala fide. So if this goes, that's why, my lord, I am telling your lordship. Now, my lord, so if the acquisition is not bona fide purpose, the ground of delay and acquisitions in the present case has no substance. No, their main contention is, one of the main contention is delay. Second contention, we have accepted the award. Learned counsel for the appellant tried to persuade us that as the amount in question has been accepted by the respondents, kindly see, has been accepted by the respondents, it is not open for them now to wriggle out from the agreement. It may be that the appellant might have tried to settle out the acquisition, but when the whole acquisition emanates from the aforesaid 1010 notification, any settlement on the basis of that notification cannot be validated. So whether we have agreed, whether we have entered into an agreement, or whether we have accepted the award or not, although we have not accepted, we have filed reference petition. But if the acquisition is based on a tainted notification, then, my lord, everything goes. Acquisition from tainted notification. Why I am saying it's tainted notification? Because 401A notification stood lapsed on 31st March 1995 by virtue of 7. So the notification becomes tainted. You cannot proceed on the basis of the tainted notification. Then your lordships can pose a question or the other side will pose a question. Then you have come at a belated stage. But the law has been prescribed by the state government. Law has been framed by the state government. State government is the framer of the law. So you must know what is the consequence of the law. True, you have come at belated stage, but you must know that when you are declaring the award, your notification already stood lapse by operation of law. The fact remains that when the basic notification under which the present land is sought to be acquired stood vitiated, then whatever money that the appellant has paid is at his own risk. They have passed the award. We have got the award by filing reference petition. We have filed reference petition. But whatever money that has been paid at their own risk. Why I am saying so? You know that the notification stood lapse. You ought not to have proceeded on the basis. You ought to have initiated fresh proceeding, either invoking 9.3 or 9.3b, or fresh notification under section 4.1a could have been published before 31st March 1997, because by when the award was declared, after that much time was available. Award was published in 1996. Another 1 year was there. A notification could have been published. So simply we paid the money, we have accepted the money, that will not serve the purpose. It is paid at its own risk. This is most important, once the notification goes, no benefit could be derived by the appellant. We are satisfied that issue of notification was mala fide and it was not for the public purpose, as has been observed by this court. Nothing turns on the question of delay and acquiescence. This is important, not in delay and acquiescence. Your lordship might kindly explain this. Mala fide in this case, it was purpose was not public purpose, but in our case, your notification stood left by operation of law. So question of delay and acquiescence does not arise. সেই নোটটাকে আমি রাজু আমাকে দেখালো না, খুঁজেও দেখলাম না। ঠিক আছে, মনে আছে তো, যেটা বলতে বলতে লাগছে। Then, my lord, ultimately, that was with regard to acceptance of compensation, and if the notice goes, that decision was that. There cannot be question of acquiescence, etc. The question of delay.
Yes.
Next point I want to develop is that Land Acquisition Act is a expropriatory legislation, your lordship. Similarly, Act 2 of 1948, although temporary in nature, it is a expropriatory legislation. So, the provisions of this, when the citizens' property is sought to be expropriated, so, my lord, the provisions of the Act has to be strictly followed. These are the decisions I want to submit before your lordship. First, my lord, I am submitting a 2020, 2020, Volume 4, SCC 572. This is in the context of not Land Acquisition Act, but this is in the context of Sikkim Land Requisition and Acquisition Act of 1997. It is like our Requisition Act.
Okay.
Like our Act 2 of 48. Your lordships kindly come to para 14. We may note that even though, has your lordships got it? At page 577.
Paragraph? Paragraph 16.
14. Top.
We may note that.
We may note that even though rights in the land are no more a fundamental right, but by that time, my lord, 1978 amendment, my lord, the right to property taken away and constitutional right inserted under 300 Article A. Still, it remains a constitutional right under Article 300A of the Constitution of India and the provisions of the Act seeking to divest any person from the rights in property have to be strictly followed. So, my lord, you cannot say, you cannot put the blame upon me that you have come at belated stage, but what you have done, you are required to strictly follow. You must follow 7A. Must follow 7A. Then, my lord, it is para 15. It is also settled law that following the procedure of section 4(1) of the Land Acquisition Act, akin to 5(1) of the Act, in our case, akin to 4(1)A, is mandatory, and unless that notice is given in accordance with the provisions contained therein, the entire acquisition proceeding would be vitiated. An entry into the premises based on such non-compliance would result in the entry being unlawful. The law being expropriatory in character, the same is required to be strictly followed. The purpose of the notice is to intimate the interested person about the intent to acquire the land. These provisions, as they read of the said Act, thus also required to be so followed. Here, in second paragraph, there are, your lordship might have remembered, there under section 4(1) of the Land Acquisition Act, when the government wants to acquire a property for a public purpose, they will issue a notice under section 4(1). Wherein the provisions have been made that first of all, you are to publish a notification in the official gazette. Then, my lord, you are to publish the notification in the 2 or 3 daily newspapers. And thirdly, lastly, you must also, my lord, display the public substance of the notification in the public place.
Yes.
These are the 3. So these are the mandatory provisions. If any of the provisions is violated, then my lord, the notification will go. Similar, another judgment, my lord.
So here notice is the issue.
My lord.
Here notice is the issue.
Notice is the issue.
Notice.
And yeah, in our case,
notice is the issue.
in our case, notice is also the issue. Notice 7A, stood lapse. You are taking away on the basis of the notice. You must follow the provisions of section 7A. You must declare the award within the statutory period. Then, my lord, another judgment on the same point is AIR 2002 Supreme Court 1334. But this is a constitution bench judgment, kindly remember. This AIR 2002 Supreme Court is 1334 is a constitution judgment, 5 judges bench judgment.
Yes.
Your lordships kindly come to para 7. It is in the context of Land Acquisition Act.
Yes.
Para 7, kindly come to para 7. But as the factual scenario shows, in the case at hand, the notification under section 4(1)A of the Act was issued and the declaration was made prior to substitution of the existing proviso of section 6(1) by Act of 68 of 1984 with effect from 24th of August 1984. In other words, the notification under section 4(1) issued before the commencement of the Land Acquisition Amendment Act 1984, but after the commencement of the Land Acquisition Amendment Validation Ordinance 1967, replaced by Land Acquisition Amendment Act Validation Act 1967. But the substituted provision was in operation on the date of impugned judgment. In terms of the proviso of the the declaration can be made under section 6 in respect of any land covered by the notification under section 4(1)A of the Act after the expiry of 3 years or 1 year from the date of its publication, as the case may be. The proviso deals with 2 types of situation. It provides for different periods of limitation depending upon the question whether the notification under section 4(1) was published prior to commencement of Land Acquisition Amendment Validation Ordinance 1967, but before the commencement of the Land Acquisition Amendment Act 1984, or 2, such notification was issued after the Land Acquisition Amendment Act 1984. In the former case, the period is 3 years, whereas in the later case, it is 1 year. Undoubtedly, the notification under Section 6(1) was made and published in the official gazette within the period of 3 years prescribed under the proviso thereto, and undisputedly, the same had been quashed by the High Court in an earlier proceeding. It has to be noted that the explanation 1 appended to Section 6(1) provides that in computing the period of 3 years, the period during which any action or proceeding is to be taken in pursuance notification under Section 4 instead by an order of this court shall be excluded under Tamil Nadu Act such and such. The expression used is action or proceeding is held on account of stay of injunction, which is contextually similar. Now, what I am saying in this case, it was found. What happened? Originally, Land Acquisition Act was there, 1894 was there.
Yes.
In 1984, major amendment of Land Acquisition Act was made by Land Acquisition Amendment Act 1984. Prior to introduction of Land Acquisition Amendment Act 1984, there was no provision for lapsing of Section 4 or Section 6. For the first time in 1984 Amendment Act, lapsing provisions were introduced. Therein, 2 periods were prescribed. If the notification under section is published prior to commencement of, after the Land Acquisition Ordinance, Validation Ordinance 1967, or before the commencement of 1984 Amendment Land Acquisition Act, then the award is to be declared that the declaration under section is to be published within a period of 3 years.
Yes.
In other cases, if it is done after the introduction of Land Acquisition Amendment Act 1984, then the period will be 1 year from the date of Section 4 notification. So these provisions are mandated. But in this case, was published within 3 years. So, but High Court wrongly it was set aside. So this was the position. Now kindly come to para 10. So it says that you must declare the award within the period specified in the Land Acquisition Act, which was introduced by way of Land Acquisition Amendment Act 1984.
Yes.
Then it may be pointed out that the stipulation regarding urgency in terms of Section 5A of the Act has no role to play when the period of limitation under section is recorded. Pointed out the stipulation regarding urgency, but that is under Section 17. The purpose for providing the period of limitation seems to be avoidance of inconvenience to a person whose land is sought to be acquired. Compensation gets paid from the date of notification under Section 4(1)(a). Section 11 provides that the valuation of the land has to be done on the date of publication of notification under Section 4(1). Section 23 deals with the matter to be considered in determining the compensation. It provides that the market value of the land is to be fixed with reference to the date of publication of notification under Section 4(1)(a). The prescription of time limit in this background is therefore peremptory in nature. So whatever time limit has been prescribed under the Land Acquisition Act, that is peremptory, that should be followed.
Yes.
That I want to rely. Another one judgment, on the same issue. So, so kindly, I once again reading the remaining portion. In the Ramchand and others, versus Union of India and others, 1994 one SCC, it was held by this court that though no period was prescribed, action within the reasonable time was warranted. What happened in Ramchand's case? But that case was filed prior to 1984 Amendment Act.
Prior to 1984.
Land Acquisition Amendment Act 1984.
Okay.
Wherein Section 4 was published, and the facts of this Ramchand case is this. 4(1) is published sometimes in 1960.
Okay.
So by virtue of Section 23, valuation pegged on the date of notification in 1960, and the government waited for 20 years. No award was declared. Then, the landowners came to challenge that action of the government that you cannot wait for such a long period. So that was the basis of that. It was published prior to that. Then Miller prescribed. Time limit was within the reasonable time was warranted. The said case related to a dispute which arose between the prescription of specific period. After the passing of declaration, the same became nullest and was effaced. It is fairly considered by the learned counsel for the respondent that there was no bar on issuing a fresh declaration after following the due procedure. It is, however, contended that in case a fresh notification is to be issued, the market value has to be determined on the basis of the fresh notification under Section 4(1) of the Act, and it may be costly affair for the state. Even if it is so, the interest of the person whose land is sought to be acquired cannot be lost sight of. He is to be compensated for acquisition of his land. If the acquisition sought to be made is done in illogical, illegal, and irregular manner, he cannot be made suffer for the account. This portion I am delaying. But here is an award has been declared, but the last 4 or 5 lines, even if it is so. This is important. You cannot declare the award resorting to illogical, illegal, or irregular manner. In our case, kindly remember for a moment, just one sentence. 1971 requisition, 1980 4(1) notification. Then they for another 15 years to declare the award. And in the meantime, the notice to lapse by operation. So what they did? They did illogical. So total 25 years from taking possession of the land. But at that, your lordship might remember, at that government used to act in such a fashion that everything belongs to them. Landowner's property, they have no right to challenge, etc., etc. Then we are next. AIR 2007 Supreme Court 1411. AIR 2007 Supreme Court 1411. But kindly come to para 14 and 17.
Paragraph
14. 14. 14, 16 and 17. সেই নোটটার মধ্যে আমি কারেন্ট যেগুলো দেখাবো সেই তো নোটটা আমাদের তা কিছুই যে আমাকে বলে না, আমি ওকে দেখাবে, আমি একবার দেখা হয়নি। Para 14. Proviso II appended to subsection 1 of section 6 of the Act clearly reverse making of any declaration in respect of any particular land covered by a notification issued under subsection 1 of section 4 after the expiry of 1 year from the date of publication thereof. Explanation 1 of the appended to said proviso, however, stipulates that in computing any of the periods referred to in the first proviso, the period during which any action or proceeding to be taken in pursuance of the notification issued under section 4(1) is stayed by an order of the court shall be excluded. On plain reading of the aforementioned provision, there cannot be any doubt whatsoever that the period which is required to be excluded would be 1, during which the action or proceeding taken was subjected to any order of stay passed by the competent court. Then we will kindly come to para 16. In Hindustan Petroleum Corporation Limited versus Darius, Sahapur, Chennai and others, 2005, 7 SCC 622. So ahead. The Act is an expropriatory legislation. This court in State of MP versus Vishnu Prasad Sharma observed that in such a case, the provisions of the statute should be strictly construed as it deprives a person of his land without consent. Then 17. We have noticed herein before that the proviso appended to subsection 1 of section 6 is in the negative term. It is therefore mandatory in nature. Any declaration made after the expiry of 1 year from the date of publication of the notification under subsection 1 of section 4 would be void and of no effect. An enabling provision has been made by reason of explanation appended thereto, but the same was done only for the purpose of extending the period of limitation and not for any other purpose. The purpose and object of the provisions of the Act and in particular the provisions which had been inserted by Act 68 of 1984 and which came into force with effect from 24th of September 1984 must be given its full effect. The said provision was inserted for the benefit of the landowners. Kindly mark this. Such a statutory benefit thus cannot be taken away by purported construction of an order of a court, which in our opinion is absolutely clear and accessible. So, my lord, in our case 7A, if we go to once again 7A, it is for the benefit of the landowners. There must be end of a proceeding. Unless you do it within certain period, it will go. So it is for the benefit of this. Next, Mirror, they have said that we are stopped from challenging the acquisition proceeding at such a belated stage. That is one of their contentions. So, Mirror, I want to cite two decisions on this point, that there cannot be any estoppel against the statute. Yes. As judgment, Mirror, your lordships kindly read, Mirror, AIR 2002 Supreme Court 1157. Huh. 1157. Para 12 III.
No estoppel against the statute.
Yes. Para 12 III. Kindly come to page 1161. Para 12.
Yes.
Kindly come to III, where ground is based upon breach of mandatory provisions of law. A party cannot be stopped from raising the same in his objection to the award, even after he participated in the arbitration proceeding in view of the well-settled maxim that there is no estoppel against the statute. Here in this case, award was sought to be challenged. Here in this case, not award published under the Land Acquisition Act or the West Bengal Land Acquisition and Acquisition Act. There cannot be estoppel to challenge. Estoppel, Section 7A is mandatory. You cannot stop me from saying that the award has been passed in violation of 7A. But a similar thing has been observed in AIR 2004, two more judgment, Miller. AIR 2004 SC 1704. Finally come to para 9. Para 9.
Yeah.
In Upton India Limited versus Sami Bhan and others, right, reported in another 1998 SCC, it was held that a case decided on the basis of wrong concession of a council has no precedent value. Has no precedent value. That apart, the applicability of the statute or otherwise to a given situation or the question of statutory liability of a person, institution under any provisions of law would invariably depend upon the scope and meaning of the provisions concerned and has got to be adjudged not on any concession made. Any such concession would have no acceptability or relevance while determining the rights and liabilities incurred or acquired in view of the axiomatic principle without exception that there cannot be any estoppel against the statute.
Yes.
Last 4 lines, most important. Then, Mirror, one judgment, Mirror, I want to cite 2016 6th patient 2016 6 150 লিখে নিন 2016 ভলিউম 6 SCC 150. 150. 16.6. SCC 150. But only one line I will rely. But kindly only read passing of the award by itself. Kindly come to para 15. Para 15.
Yes.
Passing of the award by itself does not mean that there any illegality should not be addressed. This line I am relying upon. So, award has been passed. Even
Only
after
because of the reason that the award has been passed, all illegality erupt, that is not the
that
case.
is not the case. We can challenge the award if it is otherwise bad in law. Next, Miller, on the point of delay in moving the writ petition. Whether right or wrong, Miller, we have explained the delay in paragraph কত বলুন তো writ petition টা? Just a minute, Miller. Which has not been, Miller, dealt with. First paragraph, first book. To. Kindly note that, Miller, we have explained in our way, besides other statements made therein, Miller, we have explained the delay in paragraph 79, sorry, paragraph 80 of the writ petition.
180.
No, 80.
80.
80, we have said what are the reasons for delay in filing the writ petition. In the opposition, they have not challenged that, but if it is permissible in law, they can challenge. I am not saying that. They have not at least said that we have accepted the activity. They are always that make their submission. But in any case, which has not been denied or dealt with. Para 80, para 80, page 68 of the writ petition, volume 1. Now, I am coming to the case laws. What is the 2020, volume 2, SCC 569. Para 12.12, 12.13, and 12.14. Has your lordship got it? 12.2 at page 572. Well, here in this case, of course, no award was there, but in this case, it is a well-known judgment now. It has been followed in subsequently in other judgment. Here in this case, in 1960s, when property of the other landowners were acquired, the land of the petitioners herein, their property was by mistake or whatever reason
also acquired.
Not acquired, but possession was taken and utilized by the government. That means property was taken without payment of compensation.
Without any notice.
Without any notice, etc. Then, the writ petition was filed, claiming compensation. That writ petition was filed, and government plea was that by that time, since 1965, we have acquired adverse possession in that property.
Government pleaded adverse possession.
Government claiming adverse possession. That has been deprecated by the Supreme Court. In this background, kindly come to read para 12.2. The right to property ceased to be a fundamental right by Constitution 44th Amendment Act 1978. However, it continued to be a human right. It has been explained in several judgments. in a welfare state and the constitutional right under Article 300A of the Constitution. Article 300A provides that no person shall be deprived of his property save by authority of law. The state cannot dispossess a citizen of his property except in accordance with the procedure established by law. The obligation to pay compensation, though not expressly included in Article 300A, can be inferred in that article. Then we have 12.3. To forcibly dispossess a person of his private property without following the due process of law would be violative of a human right, as also the constitutional right under Article 300A of the Constitution. Reliance is placed in the judgment of Hindustan Petroleum Corporation versus, that has been also explained there, Darius Sapur Chennai, wherein it has been observed. Having regard to the provisions contained in Article 300 of the Constitution, the state in exercise of its power of eminent domain may interfere with the right of the property of a person by acquiring the same, but the same must be for public purpose and reasonable compensation therefore must be paid. Then we are 24. In N. Padma versus Ramakrishna Reddy, this court held that if a right to property is a human right, as also a constitutional right, the same cannot be taken away except in accordance with law. Article 300A of the Constitution protects such right. The provisions of the Act seeking to divest such right, keeping in view of the provisions of Article 300A of the Constitution, must be strictly construed. So, this is in the context of delay. So, what in our case, we cannot say that the initial taking over of possession was bad, but the initial taking of possession was right, no problem. They invoke Section 3 of the 1948 Act. Then, in order to acquire the property, they publish notification under Section 4(1)(a). Then, the property is vested in this state. And taking of this, benefit, the state government ultimately declared the award not within the period prescribed under the Act. So, what I am saying, when the award is passed beyond the statutory period, that is a statutory violation of the Act provided in the Act. So, that is my substantive right, and that is also, you cannot take away my property. Ultimately, they are taking away my property by declaring an award, unless, your Lordship knows very well, that unless an award is declared under the provisions of the whatever Act, either under the Land Acquisition Act or under the Act 2, the proceeding is not concluded. So, they have to conclude the proceeding. Ultimately, it was concluded, but by violation of statutory provisions mandated in the Act. So, that's why I am submitting. You cannot take away my property by statutory violations of law. This is right to violation. Then, next judgment, this judgment has been followed. This is in the context of delay. I am not placing the other paragraphs of the judgment, but ultimately what the Supreme Court held, there is no delay since you are trying to take away the property without following the due process of law, which is violative of Article 300A of the Constitution.
Yes.
The next judgment is 2022, Volume 7, SCC 508. Kindly come to the like same case. Para 10. Some background I am telling you, Lordship. Here also there has been inordinate delay to challenge the acquisition proceeding. Here, what happened in this case, my lord, a large chunk of property, just background I am telling you, Lordship, large chunk of property was acquired. Then, my lord, some award was passed, some challenged the award, and my lord, award was enhanced or like that. Now, some petitioner's property, those were acquired, but they did not approach the court. Ultimately, relying upon the earlier decisions of the court, whereby compensation was assessed, they approached this court after a long lapse of time to contend that they are also entitled to get the same benefit like the others who have come to this court.
Yes.
In that background, my lord, your lordships kindly, that is the background of this case. But if I read the entire all paragraphs, it will take much of your lordship's time. Then we have para 10. Mr. Abhinav Mukherjee, learned counsel on behalf of the state of Himachal Pradesh, urged, that is the Vidya Devi is also from Himachal Pradesh, this is also from Himachal Pradesh.
Yes.
Urged that the petition was hit by immense delay and laches and liable to be dismissed on the ground alone. The appellants had approached the High Court after an inordinate delay of, kindly mark this, 38 years in 2011. Against action taken by the state in 1972-73 and an inordinate delay of about 6 years in approach the court after passing in the impound judgment in 2013. Reliance was placed on this decision of state of Maharashtra Digambor, state of MP versus such and such, Brijesh Kumar versus state of Haryana. The council also submitted that the decision in Tukaram Kona Joshi, which the appellant strongly rely, is par inquirium in the light of the larger bench decision of Digambor, which was not considered in Tukaram Kona Joshi's case. These respondents state opposes the application for the condonation of delay by filing the appellate. I have not placed so many, I do not want to burden your lordship with so many. Tukaram Kona Joshi is one of the judgment, where after a long lapse of time,
Yes.
approach, your lordship might have known, ultimately, the delay was condoned and court said that it's a human right, you have to pay compensation. Then, kindly come to para 13. While the right to property is no longer a fundamental right, Constitutional 44th Amendment, it is pertinent to note that at the time of dispossession of the subject land, this right was still included in Part 3 of the Constitution. The right against the deprivation of property, unless in accordance with the procedure established by law, continues to be constitutional right under 300A. In our case also, when the property was, although not illegally, but legally, but that was when that right was, in 1971, it was our fundamental right, when the property was taken away. In 1971, possession was taken.
1971.
1971. So prior to 44th Amendment, and at that time, my right to property was a fundamental right. Then 14. It is the cardinal principle of the rule of law that nobody can be deprived of liberty or property without due process or authorization of law. The recognition of this dates back to 1700 to the decision of the King's Bench in the Antique versus Carrington and by this court in Wazir Chand versus State of HP. Further, in several judgments, this court has repeatedly held that rather than enjoying a wider bandwidth of the lenience, the state often has a higher responsibility in demonstrating that it has acted within the confines of legality and therefore not tarnished the basic principle of the rule of law. 15. When it comes to the subject of the private property, this court has upheld the high threshold of legality must be met to dispossess an individual of the property, and even more so when done by the state. In Bishan Das versus State of Punjab, this court rejected the contention that the petitioners in this case was a trespasser and could be removed by exercise executive order, and instead concluded that the executive action taken by the state and its officer were destructive of the basic principle of the rule of law. The court in another decision, State of UP versus Dharmender Prasad Singh, held as follows. A lesser with the, I am skipping it over. Then, my lord, kindly come to para 16. Given the importance of protection extended to the individual vis-a-vis their private property embodied earlier in Article 31, now in constitutional right in Article 300A, the high threshold the state must meet while acquiring land, the question remains, can the state merely on delay and laches evade its legal responsibility towards those from the private property has been expropriated? In these facts and circumstances, we find the conclusion to be unacceptable and warranting intervention of the grounds of on the grounds of equity and fairness. Similarly, in our case, always we are saying you are taking away, but ultimately property taken possession of in accordance with under section 3. Then you want to acquire it, publish notification under section 4, property stood vested in this state. Then ultimately, vesting is not without declaration of the award. You must declare the award within this time specified in the Act. Unless award is declared, the property will be divested and owners, landowners will get their title. So, my lord, this is the position of law that that must be followed. So, delay is no ground here. Since we have said the ultimate award by which the property vested to the state is bad in law. Next judgment, I am not saying in this next judgment, what has been Supreme Court, that has been possibly in other cases that has been relied upon in but this is in the context of next judgment is next judgment is 1974-1 SCC 317. This is of course principles of condonation of delay or whether the petition should be barred by limitation or not. That has been considered. This case, of course, not under land, but it is under a service jurisprudence. Under a service jurisprudence. Kindly have a look to principle has been enunciated here. But kindly come to paragraph 10. The first preliminary objection raised on behalf of the respondents was that the petitioners were guilty of gross laches and delay in filing the petition. The divisional cadre of Mamlatdars, Tahsildars were created as far as back in November 1, 1956 by the government resolution on that day. And the procedure for making promotion to the post of the deputy collector on the basis of divisional select list, which was a necessary consequence of the creation of the divisional cadre of Mamlatdars, Tahsildars, had been in operation for a long time of years at any rate from 7th April 1961, and the rules of July 30, 1959 were also given effect to since the date of their enactment, and yet the petitioners did not file the petition until July 14, 1969. There was a delay of more than 10 or 12 years in filing the petition since the accrual of the cause of complaint, and this delay contended the respondents was sufficient to disentitle the petitioner to any relief in petition under Article 32 of the Constitution. At that time, it was 32 was moved. We do not think this contention should be prevail with us. In the first place, it must be remembered that the rule, this is important, that the rule which says that the court must not inquire into belated and stale claims is not a rule of law, but a rule of practice. This is important. It is not a, whether belated or not, it is not a stale claim, it is not a rule of law, but a rule of practice based on sound and proper exercise of discretion. And there is no inviolable rule that whenever there is a delay, the court must necessarily refuse to entertain the petition. Each case must depend on its own fact. The question as pointed out by Hidayatullah J. in Tilokichat Motijat versus H.B. Munshi is one of the discretion for this court to follow from case to case. There is no lower limit and there is no upper limit. So, this is most important. There cannot be any lower limit or there cannot be any upper limit.
Yes.
It will all depend on what the breach of the fundamental right and the remedy claimed are and how delay arose. Thereafter the case, case of this So, up to this I am saying Milord, there is no upper limit of moving the petition, there is no lower limit.
It depends.
It depends upon the facts and
That's
case, circumstances of each of the case. Now, next, Milord. Next, Milord, it is on two aspects. এখানে আমার সব প্যারাগ্রাফ গুলো লেখা ছিল রাজু আমার কাগজে সমস্ত কারেকশন করা এদের সব অদ্ভুত ব্যাপার এরা এখানে কাগজ জোগাড় করে কাগজ ছাপা Milord, next judgment I am switching to Milord second aspect. First aspect with regard to declaration of award, challenge to award, I have tried to Milord assist your lordship to show that there is although there is delay, but there is really no delay at all because there has been infraction of statutory violation. We have come before your lordship after giving explanation, whatever explanation is available to us. Now, my lord, next second aspect is one of the most important aspects because we have said that the till date, but at least the corporation has not disclosed in its affidavit that what portion of the requisition land or what portion of the land in respect of which award has been passed has been utilized for the purpose for which it was sought to be acquired. There is
the dumping ground.
Milord?
For the dumping ground.
Yes, for the dumping ground. No statement. Immediately after passing of the award, they thought that the ownership has passed on to them. Oh, so they can deal with the property, Milord, in whatever manner they like. That's why immediately after passing of the award, initially about 30 acres of land was Milord, settled with by 35 years or 30 years lease to Chandragin projects, respond number 6 or 7. Thereafter, from time to time, at a huge money, the property has been leased out to various private companies, including LICI of company. LICI may not be a company, as a private company, but the purpose for which it was taken, that will be most important. Whether they want to take lease of the property for purpose of using the land for any other public purpose. As I have explained to your lordship, there is a host of decisions that if a property is sought to be acquired under public purpose, then the property can be used by the government for any other public purpose. We cannot have any grievance of that. But here,
that is to say, when a property was taken for the purpose of government graveyard, thereafter it was said that the property was taken for the road.
Yes.
That is all both are the public purpose.
Yes,
it
no,
can be.
No, it can be.
It can.
It for any other public purpose.
Public
there
purpose
is no,
has to be there.
There are no dispute with regard to this proposition of this. But when the property is sought to be developed by granting it to private landowners or private company or developing the land,
yes,
that is the Milord purpose will not be a public purpose and the property cannot be used in this fashion. That is my contention. We have explained in this writ petition. So, Milord, on this point, Milord,
yes,
I am relying upon 2011, Volume 10, Supreme Court Cases 608.
Other than public purpose.
Yes, other than public purpose, how it can be settled. Number, before placing the Milord, I have to, since this relates to handing over of possession to private party, I have to place the judgments in detail or in length. I will place that.
Yes.
Because that is my one of the most important ground to
Yes.
challenge the transfer of the land to private company. Now, in this case, what happened? Initially, the property was sought to be acquired for the tourism purpose. Then, Milord, when the property was sought to be acquired for tourism purpose, then, Milord, another person was there. Milord, he actually wanted to develop that land. So, Milord, he made agreement with the Milord, tourism company belonging to the government and other private landowners, etc., etc. Why I'm just background. This has 4 cases involved, 4 writ petition involved in this case have been explained here. Stage by stage, the acquisition was allowed and acquisition was quashed by the High Court and ultimately by the Supreme Court. This is the background. On the ground that it has been dealt with not in the manner as for any other public purpose. Rather, deviation of the purpose. Kindly come to page 611, para 1. Whether para 1 at page 611.
Yes.
Whether the land acquired by the state government at the instance of Karnataka State Tourism Development Corporation, for short the corporation, for the specified purpose, that is golf cum hotel resort near Bangalore Airport, Bangalore, could be transferred by the corporation to a private individual and corporate entities in the question which arises for determination of the appeal filed against the judgment of the Karnataka High Court, whereby the acquisition of the land measures 1 acre 3 guntas comprised in survey number such and such was quashed. Number I will subsequently on the next day I will give a gist of this. What happened to this case, I will give a gist of this in writing. Only in respect of this case. Very complicated issue involved here, factual aspect. Then the facts relating to acquisition of the land of 3 cases. Or next page, para 2.
Yes.
The facts relating to the acquisition of land and details of the 3 cases decided by the High Court in 1991. On requisition sent by corporation, the state government issued a notification notification dated 29 December 1981 under section 4(1) of the Land Acquisition Act 1894 for acquisition of 39 acres 27 guntas of land comprised in various survey numbers, including survey number 122 of Kodihali and Chalaghata villages, Bangalore South Taluk. After considering the reports submitted by the Special Deputy Commissioner, Bangalore, under Section 5A2 and Section 6(1)A, added by the Karnataka Act 17 of 1961, the state government issued the declaration under Section 6 in respect of 37 acres, 4 guntas land. A combined reading of the 2 notifications makes it clear that the public purpose for which the land was sought to be acquired was to establish a golf cum hotel resort near Bangalore Airport, Bangalore, by the corporation. The Special Land Acquisition Officer passed an award dated 7th of April 1986. However, as will be seen hereafter, instead of utilizing the land acquired for the purpose specified in the notification or for any, this is important, or for any other public purpose, the corporation transferred the same to private party. Number 3 and 4 relating to one private party who wanted to acquire the land or who wanted transfer from the corporation or from landowners. He entered into various agreements so that he can utilize
Developer.
for development.
Yes.
3 and 4, I am skipping it over. Then 5, Mr. Behorj Ramaya Batha and others who owned different parcels of land which were transferred by corporation to Dayanand Pai, earlier Dayanand Pai, filed writ petitions questioning the acquisition proceeding. The learned single judge dismissed the writ petition on the ground of delay. The division bench of the High Court reversed the order of learned single judge and quashed the acquisition proceeding qua land of the appellants in those cases. The division bench referred to the minutes of the meeting dated such and such, the resolution dated such and such, passed the corporation and observed. We have made our comments then and there. Nevertheless, we cannot refrain our feeling in commenting upon the same once over again. We cannot think of anything more despicable than the candid admission by the Tourism Development Corporation that they did not have necessary funds to required to meet the cost of acquisition. If really there was no amount available, how the acquisition was embarked upon we are left to realm of guess. Not only that, this particular resolution makes it appear that the respondent number 5, Dayanand Pai, was the only savior of the Karnataka State Tourism Development Corporation from the difficult situation. For our part, we do not know what exactly was the difficulty then. Land acquisition proceedings were complete in all material respect. All that it required was possession to be taken merely because there are writ petitions or some cases pending. Does it mean that the Tourism Development Corporation must plead helplessness? Does not it have the wherewithal to contest this litigation? Is it not a part of the government, although it be a corporation? What is it that it wants to do in consideration of withdrawal of cases which were thrown in the place of the Tourism Development Corporation? He is given on a silver saver an extent of 12 acres 31 guntas of land. To say the least, it appears right from the beginning that the respondent number 5, Dayanand Pai, had an eye on these lands. That would be evident because though he entered into an agreement on 30th September 1981 with the landowners, it never occurred to him to put forth any objection during 5A inquiry, nor again at any point of time did he make any interest. He was patiently waiting for the somebody to check the chestnut out of the fire so that he could have the fruits thereof. That is also evident from the resolution dated such and such. When the Dayananda Pai such and such. Then mirror, next paragraph. Yes, might have had a commitment. What then is the purpose of eminent? This is very important, kindly note from here. Yes, he might have a commitment. What then is a purpose of the eminent domain? Eminent domain, as we consider, that it is the settled law, as was said by Nichols, in an attribute of sovereignty, where the deputy commissioner is convinced that the lands are to be acquired for a public purpose, notwithstanding the fact that the rights of the private parties might be interfered with, the acquisition will have to be gone through. In other words, the private purpose must be subservient to public purpose.
Yes.
Forget all that. In order to enable Dayanand Pai to fulfill his commitment, a valuable portion of the lands acquired, 12 acres 31 guntas, is transferred in his favor. We cannot find a more vivid case of fraud on the power of this. Kindly mark this fraud. I have to explain this. If the property is sought to be transferred, it is exercise of fraud on power. This is exercise of fraud on power. We hold so because the apparent object as evidenced by 4.1 notification is public purpose. If really as was sought to be made out by the resolution dated such and such, the Tourism Development Corporation was anxious to have these lands and the delay was telling upon it, certainly selling away of the land is not the solution as we could see. Therefore, there had been a clear diversification, kindly market. One is fraud on power, then another is diversification of the purpose.
Yes.
Not only an extent of 12 acres 31 guntas have been sold in mirror favor of respondent number 5, Dayanand Pai, as has been noted in the narration of facts. 8 acres had come to be leased for Bangalore International Center, and another 5 acres of land had come to be leased for amusement park. Why all these? If the Tourism Development Corporation does not have funds to meet the cost of acquisition, therefore it appears to us that this is nothing more than a conspiracy to deprive the owners of the land by use of power of eminent domain, which is to be used for an avowed public purpose for strong compelling reasons and not whimsically or to satisfy the private needs of the individual. Then the division bench then referred to some judicial precedents, including the judgment in Industrial Development and Investment Corporation Limited versus State of Maharashtra. But in the case on hand, what is most striking is that negotiations took place even before taking possession of land. On 8th of May 1987, an agreement was entered into, and the wake of the taking possession of 12th of November 1987, transfers are made on 23rd of March 1988 and 23rd of March, 24th of March 1988. This is where we consider that with the motive of securing lands to respondent number 5, Dayanand Pai, the acquisition had come to be embarked upon. This was the reason why we conclude that this is a case of fraudulent exercise of power. It is no consolation to say that the owners of the land have accepted the compensation because in industrial development and investment company versus state of Maharashtra, it is thus. So, this is also kindly marked that accepted a compensation. So, after that, it cannot be challenged. That is not the case. What has been held? The state, para 5, the state itself, which has acted illegally and without jurisdiction, cannot plead that it should be allowed to retain the sum awarded in its favor by the land acquisition officer. Respondent number 5, who is described as the owner of the land, has conveyed to us that it would submit to the order of the court. We also record the submission of Mr. Dhanuka, learned counsel for the appellant, that in the event the other awardees who are awarded poultry sum by the award under Section 11 of the Land Acquisition Act do not refund the sums withdrawn. The appellants are prepared to refund and deposit the said sum. Therefore, we conclude that on the ground of delay, the appellants could not be deprived of the relief to which they are all otherwise entitled. So here also delay has also been explained. টায়ার্ড লাগছে এবার আর পাচ্ছি না শেষ পর্যন্ত করা যাবে না Milord, the ratio of this case squarely applies here. Not again, in our considered opinion, the previous decisions upholding the validity of the acquisition would be of any value because, as we have observed earlier, the causes of action arose on 23rd of March 1988 and 24th of March 1988 when the transfer came to be effected, or on subsequent days when the leases had come to an effected. Therefore, where the ignorance of this transaction, if compensation had come to be accepted, we should not put that against the search of the landowner. But this question does not arise in this case. Therefore, we shall relegate the same to the other cases. Lastly, what remains to be seen, what is the effect of, this is important, what is the effect of fraud? Does it render the entire acquisition bad, or is it to be held to bad only so far as the appellants are concerned? We are of the view that the fraud unravels everything. It cannot be valid in part and invalid in other parts. But we need to go to that extent because there are other writ petitions, including a writ appeal, in which these questions may arise directly. We do not want to prejudice those petitioners appellant. Therefore, this question we relegate to those cases. No, madam, I'm not feeling very
Okay, no.
tired, my lord. Then the next day, my lord, I will conclude.
Okay.
Next day, my lord, I will conclude. But next day, মানে যেদিনে fix হবে, my lord. From the morning, my lord, I was not feeling well today. But
No, very well. Not necessary. You have to must mention me earlier so that I can release.
No. I will conclude on the next day. My lord. No, only one matter is fixed today.
Yes, only one matter.
Next Thursday or
July 17th কি রেখেছো?
আর দুটো জাজমেন্ট হয়ে তো গেছে, আর তো না এই জাজমেন্ট অনেক সময় লাগবে, বেশি লাগবে না। ঠিক আছে,
কবে of July. 17th of July. Coming 2 weeks, I will not be here.
Oh, very well.
I will circuit.
I could not have been in any case completed today.
No, very well.
On the next day, I will.
Yes.
17th of July.
May I request my learned senior can give us a short notes?
Let him finish. Let him finish.
Subject is a new not a very easy subject for us to understand. That's why.
No, let him finish. Thereafter,
Yes.
Let
very well. Argument on behalf of the petitioner continues. Let the matter appear in the list.
লিখে রাখ, Thursday তো 17 July.
17th day of July 2025. Mark at 2 p.m.
Yes.
Obliged.
Very much obliged.
Singoli,